Yes. For judgment, item number 1. It is partly allowed. Item 2. Is partly allowed. Partly only. Item 3. Appeal dismissed. Dismissed. Item 4. Appeal is allowed. Item 5. Appeal allowed. Item 6. Partly allowed. Item 7. Appeal is accordingly partly allowed. Item 8. It's allowed. Item 9. Appeal dismissed. Item 10. Dismissed. Item 11. Appeal allowed. Item 12. Dismissed.
Pardon to mention, Lordship.
Yes.
In CRL number 498 of 24 and CRL 505 of 24, Lordship grant the interim bail for period of 3 months that will expire on 4/3/26. 10-year conviction, the custody in 8 years.
Division bench.
Lordship,
Single.
10 years condition on 20B2 NDPS.
I have granted bail.
Lordship.
Just check it up with this.
Another appeal for a hearing.
We will check it if it is to come before this court, it will come. Otherwise, check it up. Yes.
Judgment on the results, prepare a note for a written motion.
Okay. Take. Thank you. Thank you, madam. Yes. Yes. Supplementary list. Item 13.
May I please, Your Lordship? My lord, this is with regard to that.
Mr. Mishra, while I was dictating the order, I discovered this is an appeal where you have moved an application for grant of bail. In a pending appeal, you moved an application. It is not assigned to this bench. Had it been a separate bail application, it could have been handled by me. But this assignment is of some other court.
My lord, at the time when Your Lordship had, it was Your Lordship's assignment. Once the order is resolved, my lord, Your Lordship.
That time,
Yes, my lord.
no, I have asked for the
Yes.
interim arrangement. Only the bail applications are to come, not the appeal itself. That's what I have asked for an explanation. How they have got listed this matter.
Oh,
See, had it been a simple bail application, there is no problem. If I am sitting singly, it can come and I can do it.
Right.
But it is an appeal of 2024. And in that 2024 appeal, you moved an application for bail.
yes.
So it has to go to that bench which is dealing with the appeal. How this matter is listed like this?
I thought it is a special assignment.
You are not, no, not.
Because had I even knew that, I would have also pointed out to you.
Yes, that is escaped. I also heard it. This happens.
Man.
And you are more busier than anyone else.
No, it is not that way. So far the assignment is concerned, my lord, to be very
Right,
honest.
so go see what happens is not that this matter is a great deal dealing with a particular matter. The registry has to be,
I always ask my associate where the matter. The
I don't know.
assignment.
It is this appeal has to go to which bench? Madam Rathop's bench, assigned bench. The appeal, all the appeal goes there. So I'll just simply say that list it before the assigned bench.
My lord, because that
appeal
cannot
along
be,
with the bail application.
Because there cannot be any embarrassment that way, because that will have quite ramifications. Even assignment, non-assignment orders have been challenged and set aside only on the ground of not being assigned.
No, there are many implications. Why to
Yes.
get into all this thing?
Yes.
So that's let us make it very
Maybe I'm little unlucky because here I do not know what would have been the result, but the prima facie view was in my favor in court proceeding.
The
If
same
not-
same thing will happen there also. Don't worry.
Well,
And every case has its own,
absolutely,
the-
absolutely.
people say
I
that
just I thought
Janam Kundli for individual.
I thought
and
because
case
the
has also Janam.
note is not tagged, therefore it has come.
No, that's-
My,
I was giving dictation, then I realized
my,
that it is not fair for me. Thank you very much. Thank you.
Absolutely.
Sorry for
No, we have to be also
keeping
with that process because
we have to
otherwise,
strictly follow. Otherwise, see the registry people will
absolutely, man, absolutely.
create a lot
Okay.
of problems. Okay. Yes.
Item 14, status report.
Hmm?
Status report.
Status report. Yes, you got it.
Yes. Yes.
Is maintaining his livelihood by cultivating. Okay. Alive, huh? Yes. Weekly including. Yes. 97 matter. Yes.
Item 15,
Yes.
I have prepared it, I'm submitting it, I have already soft copy. Yes.
It's partly hard, Your Lordship.
This you are written note.
Yes. Phase 3,
Case 3.
submission starts from.
Case 3. Yeah? Yes. Submissions. Yes.
In this case, to sustaining the gunshot injury, PW1 narrated the incident to her husband, who was also examined as PW4.
Hmm.
And the evidence of PW4 is admissible under section 157 of the Evidence Act, and that will be treated as corroboration to the evidence of PW1. Second, my lord, they raised a contention that it was not sent to the ballistic expert for examination, and ballistic expert was not examined. But that, my lord, I have relied upon a Supreme Court decision in the Honorable Apex Court held that is not an inflexible rule that in all cases
Yes.
ballistic expert has to be examined.
Which judgment you are talking about? The first one?
First one, my lord, on 157, 85 4 SCC 212. Second one,
Para 9 you are relying upon.
yes. So far as the second concern, that is, my lord,
Let us see the para 9. Para 9. Madam, have you got the written note of submission? Just the para 9 of the first judgment. Just read it.
In our
What?
view, the reasoning and appreciation suffer from a legal error and almost sound perverse. Assuming that the complainant's conduct in narrating all that transpired on March 10 to 3 of her colleagues is not res gestae, and hence inadmissible under section 6 of the Evidence Act. The same, when corroborated by the 3 witnesses, is clearly admissible under section 157 of the Evidence Act, and therefore ignoring such crucial and relevant evidence has led the court to give undue importance to the so-called delay in lodging the report with the police. In fact, it could not be regarded as a case of any delayed report, for it should have been appreciated that it was the second incident when the accused actually assaulted the complainant by catching hold of her arm and tried to outrage her modesty, that the culminating point was reached, and immediately the same evening of March 18, she lodged her complaint with the police. It is surprising that the High Court, without paying any attention to this legal error, impliedly confirmed the Sessions Court's view about the inadmissibility of that evidence. It is thus clear that subsequent conduct on the part of the complainant in narrating all that transpired at the accused residence to 3 of her colleagues on the following day, supported as it was by the 3 witnesses, lent ample corroboration to the story.
Yes.
So far as concert injury is concerned, another aspect, your lordship may kindly for a moment have a glance exhibit 17. The guard diary,
Exhibit 17. No?
exhibit 17.
Yes.
That is the diary of D. Gangavada ANPP camp, entry dated 18/11/1992, 6:30 p.m.
1811.
18/11/92, 6:30 p.m. On the date the occurrence took place.
Where does it say 6:30?
That is there, my lord. Serial number 9, page 116.
No, 6:30 p.m. Yes.
Yes. ଉକ୍ତ ସମୟରେ S-143 ପିକେ ସରଙ୍ଗୀ ଡି ଗଙ୍ଗାବାଡ଼ କ୍ୟାମ୍ପରେ ପହଞ୍ଚି ତାଙ୍କର ନିଜ ରାଇଫଲ ସଫା କରି ତେଲ ଦେବା ସମୟରେ ମୁଁ ନିଜେ ଦେଖି ଉକ୍ତ ସିପାହୀଙ୍କୁ ପଚାରିଲି, ବର୍ତ୍ତମାନ କ୍ୟାମ୍ପରେ ପହଞ୍ଚିଲା ଆଉ ସଙ୍ଗେ ସଙ୍ଗେ ରାଇଫଲ ସଫା କରୁଛ ଆଉ ତେଲ ଲଗାଉଛ, ତେଣୁ ଉକ୍ତ ସିପାହୀ କହିଲେ, ମାଗାଜିନ୍ କରି ଆସିଥିବା ସମୟରେ, ଚାର୍ଜ ମାଗାଜିନ୍ କରି ଆସୁଥିବା ସମୟରେ ଗୋଟିଏ ରାଉଣ୍ଡ ଫାୟରିଂ ହୋଇଯାଇଅଛି। ଏହିପରି ଶୁଣି ତାଙ୍କର ଗୁଳି ତଦାରଖ କଲି ଓ ପ୍ରକୃତରେ ଗୋଟିଏ ଏମ୍ଟି କେସ୍ ଏବଂ 19 ରାଉଣ୍ଡ ଜୀବନ୍ତ ଗୁଳି ଥିଲା, ତେଣୁ ଉକ୍ତ ସିପାହୀର ରାଇଫଲ ବାୟୋନେଟ୍ ସହ ଜୀବନ୍ତ ଗୁଳି 19 ରାଉଣ୍ଡ ଓ ଏମ୍ଟି କେସ୍ ସିଜ୍ କରି ନିଜ ଜିମ୍ମାରେ ରଖିଲି। So he cleaned the gun and applied oil. No purpose could have been served by sending it to the ballistic expert.
That's the problem. He cleaned it, huh? Cleaned it by applying oil.
And third decision I relied upon regarding absence of motive. The Honorable Appellate Court held that though it is essential, but absence of motive is not fatal to the prosecution case in all the cases. The evidence is available.
Which judgment that is?
That, my lord, 2021-20 SCC 24,
Number 2, huh?
number 3, mine.
Number 3, okay.
2021
Yes.
20 SCC
Very-
case 24.
You are relying about para 25.
25.
Yes. Let's see.
We are thus of the considered opinion that whilst motive is infallibly a crucial factor and is a substantial aid for evincing the commission of an offence, but the absence thereof is, however, not such a quintessential component which can be construed as fatal to the case of the prosecution, especially when all other factors point towards the guilt of the accused and testaments of eyewitnesses to the occurrence of a malfeasance are on record.
Where does it say ballistic thing?
Para 25. Para 24, their lordships relied upon the Bipin Kumar Mandal case. And para 25.
Yes, Vipin Mandal. Yes.
As far as section 27 is concerned, I am considering same decision. It is also relating to a police personnel. Para 29 to 33, he will not be convicted under section 27 Act will not be convicted.
Para 20?
29 to 33. My place.
Yes.
Para 29, adverting to the conviction of the appellant under section 27 of the Arms Act, it appears to us that the trial court has erred in arriving at its culpability. There is no gainsay that in order to prove a charge under section 27 of the Arms Act, the prosecution must necessarily demonstrate contravention of either section 5 or 7 of the Act. In the instant case, although not explicitly stated, it appears that the trial court has held it to be a case of breach of section 5 of the Arms Act, which stipulates that no person shall use, possess, manufacture, etc. any firearms unless such person holds a license in this behalf and prescribes a minimum punishment of 3 years of imprisonment. Thereafter, para 30, their lordships quoted section 5 and 7. Now, para 31. True it is that prior to the amendment of section 27 of the Arms Act by the Arms Amendment Act 1988, the said provision penalized the use of any arms and ammunition for any unlawful purpose. However, post its amendment, section 27 of the Arms Act is strictly confined to violation
5 and
of
7.
sections 5 and 7. And
So therefore, unless 5 and 7 satisfied, then 27 will not
yes.
count.
Since
So
the police
license is not.
see the sepoy and authorized to carry a
So
firearm.
27 goes.
It may be a misconduct. 27 goes.
Maybe that's a different story.
That time.
Yes. Yes, madam, you want to add anything?
Your Lordship, kindly see the FSL report, which is page 59, my lord.
Official report?
Yes, your
Which exhibit is that?
that is the page 59, last paragraph, your Lordship.
59 of the paperwork, what?
Paperwork is
59 of what? TCR?
uh, the Caesar list medical examination of there is, your Lordship, it's 59, maybe 130 something.
No pagination, nothing.
In the PDF.
50, how much you said? 50?
9, your Lordship. PSM 59 is the paperwork. It's Orissa Police District Forensic Science Laboratory. Report, your Lordship.
Hmm.
130.
Orissa Police, District Forensic.
Yes, your Lordship.
ठीक है.
The last
59.
paragraph suggested you my lord.
59, yes. Page 59.
Photographs.
This is exhibit 19.
Yeah.
Exhibit 19, okay. Exhibit 19. Exhibit 19. Yes. What do you want to say?
Of the scene of
Where are you reading?
the last paragraph, your Lordship. Next page.
Photographs.
Huh. Were recorded from the different angles, the photographs and the footprints is
In front of the hurt.
heart was not
suitable
For example,
comparison.
comparison.
Purpose as the soil tracked the footprint shoe found at a distance of 75 yards approximately
Was also not suitable for
suitable
comparison.
comparison. It is
Its photograph
photograph was taken
was
for
taken
reference.
for reference.
The IO is
Be
advised to
advised
send
for
the above exhibits
exhibits
to
to-
RFSL, Barampur, for confirmation and examined an opinion with the respect of the utilization of firearm and
Utilization of firearm.
utilization of firearm,
Comparison of the string,
stain,
seminal strings.
seminal stain, and exhibit. So you also
Mark D.
there is no
The
record.
sample of
The footprint.
Hmm.
The footprint was not compared in this part of honor. Exactly whether the appellant footprint is that or not.
that is not
Violet-
in view of the evidence of PW to identified him in
Your
case
Lordship,
evaluating for
there are my lord,
oral evidence is
And that-
available, why should we?
my lord, that have taken in after
Not-
4 days.
This is not a case
22
based on circumstantial evidence.
The occurrence, the incident was occurred in 18, and the footprints pictures.
How will you get out of TI period?
TI period, your lordship, the eyesight, poor eyesight, it was not examined. And it is straight away the PW1 stated that your lordship is directly not admitted that that person I identified from the identification, your lordship.
That itself
So it
goes
is-
to electoral company.
So it is your lordship, the PW1 is not support the TI parent directly, your lordship.
PW1, PW2 is
PW2's story is also not supported, your lordship. PW1 in herself is not supported the PW2.
That itself goes
See,
to show that PW1 is a truthful
after
witness.
the entire thing is taken into in the entire evidence is taken in on a holistic view. If you give 27 is not made out, that's there. But
Then 354 is also not made out, your lordship.
54 minor
but
aspect
see,
of
I told you that day, even if 354 goes, 325 stays.
325, your lordship, the examination says that the
Doctor
examiner
says
that
injury report and everything is there.
injury report, the bullet, your lordship, must have some tissues, some muscle. When it go through the elbow, your lordship,
Hmm.
the bullet must have that much of things attached to that. Where is that? The forensic lab is also not giving anything about that. If
The
that is the bullet,
minor lapses.
Person kindly see for a moment the evidence of PW1, the
PW1, huh?
observation of the government prior report.
You're reading the.
Paragraph 1,
Of the-
last 3 lines. Mark of injury on the
No,
left.
no, you are reading the evidence?
Yes,
Okay.
PW1.
Uh,
PW1, last 3 lines, para 1. Mark on in bracket. Mark of injury on the left elbow joint is visible and the witness is not able to stretch her left hand.
yes, your lordship. I'm not denying from the injury, your lordship. Whether injury is come from that bullet,
That is,
that is the question, my lord.
if the oral evidence is there, my lord.
The oral evidence, then where is the
Not
ballistic
based on
evidence?
stretching too far, madam. It's very difficult. Because see, you fired on PW1. Out of scared, she ran away. Thereafter, PW2 remained, and you committed sexual offense with her.
That is not.
And that is because see, medical evidence didn't support, so therefore 376 is not made out, 354 is there. And PW2, who suffered the sexual offense by you, has identified you in a TI pen.
But exactly.
And see, PW1, in the first line of PW1, I am not able to identify the accused present in the dock. May be correct in the sense that you fired, enter into the hurt, you fired, and he received
You're-
injury, and out of scared, he left. So he
You-
might not have seen you.
the fire, as per the examiner said that it was 4 feet, and someone is coming and entering into the house and fired someone, and she cannot identify that person who fired her. How is it possible, your lordship? Must have 1 minute or 30 seconds that had been taken, your lordship, to fire someone. That was
He was in uniform, okay, when this act was done. And when he was in the dock, he may not be in the uniform. So it's very difficult also. If you are
Then
if you wear civil cloth, it's very difficult to recognize you outside.
They have
Likewise,
But
They have not even given a suggestion to PW2 that she was not present at this point.
that's the whole difficulty. And the explanation offered by you is what is creating problem. If you would have silent, then it would have been much more better. The explanation your explanations are, you say something somewhere and something somewhere else. So that creates the doubt. Anyway. Judgment is reserved, huh? Or judgment is reserved. Thank you very much. If you want to give any judgment also, you can think of. Yes.
Supplemental weekly list.
Weekly.
Weekly list item 8.
No, I told that report.
Two appellants died, my lord. Appellant number 2 died 10 years back and appellant number 5 15 years back. All others are alive.
Appellant
Appellant number 2.
pursuant to the order dated 1/2/2026. The IIC Bhuvan Police Station has submitted report entry लिया stating as under. ये मुझे divert कर दो in the absence of obligation. Okay, rest. List it for hearing. Okay. Yes. Yes.
Item 15.
Item 15.
Item 15.
File दो.
Right, please, Your Lord's. Here, Ballot, out of the appellants, Ballot, appellant number 1, 3, 10, and 11. They breathe their last, but they are dead there.
1 minute. Date.
1, 3,
1,
10, and
3,
11. 1, 3, 10, and 11.
10, and 11. Died, huh?
Ballot.
1, 3, 10, 11, right. Udayanath Sahu died, huh? Udayanath Sahu, 3,
Udanath Sahu.
Jambu Naik.
Died. Jambu Naik. Udaya Naik.
Udaya Naik, 11.
And
No, Udaya Naik,
Udaya Naik is appellant number 10.
10.
And appellant number 11.
Amna.
Annama Naik.
Naik. Died. Now then remain is 2, 4, 4 to 9. 2 and 4 to 9.
My lord?
2 and 4 to 9
My lord.
remains. Yes.
Here, my lord, the appellants were placed under trial for the offences punishable under sections 302 and other allied offences,
Yes.
but have been sentenced to undergo sentenced under section 304 part 1 and sentenced to undergo RI for 10 years
Yes.
for the offence under 304 part 1 ballot. Here, initially ballot, the occurrence ballot is of 5/8/90. It is alleged that on the date of occurrence around 6:30 p.m., the appellants, those who belongs to Sora caste, they attacked Nakula Charana Patnaik, the deceased, while he was returning from the field. But after investigation, this report was given by PW5. Ballot may kindly take note of PW5, who is one Ketravasi Sahu. After investigation, investigating officer submitted charge sheet against 24 persons.
Yes.
Charge sheet was submitted against 24 persons, but out of them, 11 persons were placed on a trial and others, as per the prosecution case, they have not faced trial or they have absconded, my lord. My lord, as per the ballot way, before going to the evidence,
Who all are the eyewitnesses? Let us.
I'm coming to that, man. Coming to that. I'm coming to that. But let me, before going to the evidence or the evidence of witnesses, those who have been relied upon by the trial court, let me see the first information report, that is Exhibit 4.
Exhibit 4.
My lord.
Yes.
Let me see.
Exhibit 4 is something else.
Exhibit 4.
Exhibit 4 is a postmortem report.
I think ballot Exhibit 4.
Exhibit 4, postmortem report. Inquest.
Here is
Exhibit 1 is inquest, exhibit 2 is something else.
Exhibit 4, my lord. Postmortem report is Exhibit 3.
Exhibit 4 is the postmortem report here. As per this, just see the soft copy, just find out. Soft copy, just Exhibit 4. You click Exhibit 4.
Exhibit 4 is the affair.
Exhibit 4 by 1 is FIR.
Exhibit 4 by 1 is the signature of PW5 in Exhibit 4.
Just see Exhibit 4 here in the soft copy, just check it out. Check the soft copy. Exhibit 4, take it out.
Exhibit 4/1 is the signature of
It
PW5.
could be always, but here at the top, if you see postmortem report, here it is exhibit 4, 11/9/2007.
Postmortem report is Exhibit 3. As per the judgment ballot.
But here it is, if you see, just check it up. Find out the top postmortem report.
Exhibit 4 ballot.
Exhibit 4 is the postmortem.
That I'm saying. Exhibit 4 was the. I'm saying from the beginning that Exhibit 4 is the FIR.
No, you say see the postmortem report at the top, exhibit 4. At the top, just see,
No, my lord, in the record here, Exhibit 3.
The postmortem report. Okay.
click at the exhibit 4, click at exhibit 4. Huh?
Exhibit 4 भी postmortem देखो जी.
That's what I'm saying.
It भी देखो जी postmortem. But as per the judgment.
Anyway.
Exhibit 4.
But if you come down in the same exhibit 4, postmortem report at the end, if you come, that is exhibit 3/1. So maybe 3.
Maybe
Maybe
it's 3 ballot.
Yes. Let us see. Now come to FIR.
FIR.
Exhibit 4.
ballot. अद्य आज 5/8/90 रिख 6:30 ଶୁଣିବାକୁ ପାଇଲି ଯେ ଆମ ଗାଁର ନକୁଳ ଚନ୍ଦ୍ର ପଟ୍ଟନାୟକ ପିତା ଉପେନ୍ଦ୍ର ପଟ୍ଟନାୟକ ସନ୍ଧ୍ୟା 6ଟା ବେଳେ ତାଙ୍କ ବିଲରୁ କାମ ସାରି ଫେରିଲା ବେଳେ ଆମ ଗାଁର ପୂର୍ବରେ ଥିବା କପିଳା ବନ୍ଧ ପାଖରେ ହଠାତ୍ ତାଙ୍କୁ ଗାଁର ବିରୋଧୀ ଦଳର ପ୍ରଫୁଲ୍ଲ ନାୟକ ମାନେ ଖାଲି ଟେକ୍ ନୋଟ ବିରୋଧୀ ଦଳର ପ୍ରଫୁଲ୍ଲ ନାୟକ ଅନାମ ନାୟକ ଉଦୟନାଥ ନାୟକ ପାଣୁ ଛୁଆଳ ସିଂ ଇତ୍ୟାଦି ଲୋକମାନେ ମିଶି ପିଟାମରା କରିବା ଦ୍ୱାରା ନକୁଳ ପଟ୍ଟନାୟକଙ୍କର ଗୋଇଠିକୁ ହାଣିବା ଦ୍ୱାରା ଗୋଡଟି ଛିଡି ଯାଇଛି.
Profulla Naik is which accused? Profulla Naik name is FIR mein name
ପ୍ରଫୁଲ୍ଲ ନାୟକ has
is
not
9. No, 9. A9 is Profulla Naik.
no my lord, see that Profulla
Onama 11.
no my lord, Profulla has not been named in the sorry he is not an appellant before my lord.
Sorry, but here A9 is Profulla
Profulla Khalal Singh.
Khalal Singh
is different my lord. Naik is.
Acha sir. Okay. Onama Naik is
I'll
11.
come to that my lord. I'll come to that. I have prepared in that line. I'll
Yes.
draw my lord's attention to that.
Yes.
5 ଜଣ ଲୋକଙ୍କ ନାଁ ଆସିଲା. ପ୍ରଫୁଲ୍ଲ ନାୟକ, ଅନାମ ନାୟକ, ଉଦୟ ନାୟକ, ପାଣୁ ଛୁଆଳ ସିଂ
ଇତ୍ୟାଦି ଲୋକମାନେ.
ଠିକ ଅଛି ତାହେଲେ ମୁଁ କହିଦେଉଛି ଆଉ ଥରେ I am explaining it my lord.
Yes.
So these 4 persons assaulted, they are Onam Naik, Profulla Naik, Udayanath Naik. Out of these 4, Profulla Naik was not present as per the evidence of PW 7 and 8. I am not on that. Accused Panu was not facing trial. The other 2 persons, Uday Naik and Onam Naik, both are dead.
Both of them.
Both are dead
Okay.
as per the affair.
So let us write the name. You say
See, Profulla Naik, Onam Naik,
Profulla Naik, Onam Naik,
Udayanath Naik,
Onama Naik, Udaynath Naik,
Panu Chhuala Singh.
Nath Naik, Panu
Chhuala Singh.
Cholasi.
Chhuala Singh. See, Khorda side so now KR Singh, Chhuala Singh.
Then Profulla was not tried.
No madam.
Profulla Naik accused number 5.
No,
might have been-
Profulla Naik is not an appellant. I can say now.
No, but that's right. But he was tried as an accused number 5. He might have been acquitted.
Well, I'll come to that. I'll come to that. Here is a case where they are messed up in such a manner. So for that reason, I have prepared in this line.
Okay. Yes.
ଇତ୍ୟାଦି ଲୋକମାନେ ମିଶି ବିଟାବରା କରିବା ଦ୍ୱାରା ନକୁଳ ପଟ୍ଟନାୟକଙ୍କର ଗୋଟେ ଶୁଣାଂଶ ନକୁଳ ପଟ୍ଟନାୟକଙ୍କ ଘରକୁ ଯାଇ ଦେଖିବାରେ ଓ ପଚାରି ବୁଝିବାରେ ଆଜି ସେ ତାଙ୍କ ବିଲ କାମ ସାରି ଘରକୁ ଫେରିବା ସମୟରେ ଉପରୋକ୍ତ ମୁଦାଲାମାନେ ହଠାତ୍ ଗ୍ରାମ ବିବାଦକୁ କେନ୍ଦ୍ର କରି ସେମାନେ ଧରିଥିବା ଅସ୍ତ୍ରଶସ୍ତ୍ର ଦ୍ୱାରା ତାଙ୍କୁ ଆକ୍ରମଣ କଲେ ପାଣୁ ଛୁଆଳ ସିଂ ପିତା ଅପର୍ତ୍ତି ଛୁଆଳ ସିଂ ଏକ ଫର୍ସା ଧରି
Hmm.
ନକୁଳ ପଟ୍ଟନାୟକଙ୍କର ବାମ ଗୋଡ଼କୁ ପ୍ରଥମେ ହାଣିଲେ, ତାପରେ ଅନ୍ୟ ମୁଦାଲାମାନେ ମିଳିତ ଭାବରେ ଠେଙ୍ଗା ଧରି ମାଡ଼ ଦେଇଥିଲେ। ଏହି ଗଣ୍ଡଗୋଳ ବେଳେ ଉଦୟନାଥ ସାହୁ ଉପସ୍ଥିତ ଥିଲେ। ଏହି ଗଣ୍ଡଗୋଳକୁ ଶ୍ରୀ ଚୈତନ୍ୟ ସେଠୀ, ଜଳଧର ବଳିଆର ସିଂ, ପୁରୁଷୋତ୍ତମ ପାଇକରାୟ ଓ ଅନ୍ୟମାନେ ତାଙ୍କ ବିଲରୁ ଫେରୁଥିଲା ବେଳେ ଦେଖିଥିଲେ। ଶ୍ରୀ ନକୁଳ ପଟ୍ଟନାୟକ ଗୁରୁତର ଅବସ୍ଥାରେ ଅସୁସ୍ଥ ଥିବାରୁ ତାଙ୍କୁ ଡାକ୍ତରଖାନା ଆଣିବାରେ ଶୁଆଂଶୁ।
Yes.
So this Kshetrabasi Sahu
Yes.
is not a witness to the occurrence.
Yes.
He says he ascertained it from others about the occurrence.
Yes.
And he could know from whom he has ascertained that is not there. And the persons, those who have been named as witnesses to the occurrence, here another thing they have tried to introduce during evidence, which was not there in the affair, a dying declaration purported to have been made before PW12, but that has been disbelieved by the trial court.
Yes.
Valid. So if my lord would directly go to the evidence of PWs 6, 7, 8 and 9, they have been relied upon by the trial court to reach at a conclusion.
They are the eyewitness account.
Witnesses to the occurrence.
6.
My lord.
Six,
But
seven.
here one thing why I have drawn my lord's attention to the affair, that while he, after completing his field work, while deceased was returning, on the way he was assaulted by the accused persons. They have been named Prafulla Naik, Anam Naik, Udaya Naik, Panu Chwalasi. My lord.
6, 7.
My lord, I am coming to PW evidence of
So who
PW
all are the eyewitness according to you?
6, 7, 8, 9.
6, 7,
8 and 9.
9.
Eyewitness.
Correct.
Okay. Yes.
PW 6 is Jaladhar Baliar Singh.
Who is friend of her? Hmm. Yes. Yes.
And let me see the evidence of Jaladhar Baliar Singh. This Jaladhar Baliar Singh, who has posed himself as a witness to the occurrence, in subsequent trials for other accused persons, I have got one judgment and the evidence and his evidence, he has taught hostel.
Trial was split up.
Trial was splitted up. And the other 3 persons subsequently faced trial. Their PW 6 has been examined as PW 1, where he says, I have not seen the occurrence, I do not know anything about the occurrence.
What happened to that appeal?
That trial has been ended in acquittal.
That's very good.
I have got the judgment with me and the evidence of this witness.
Baliar Singh. You examined is PW1.
PW 1 in that case.
Okay. Okay. What is the law in that? Suppose the same witness in the same incident, in a
Matter.
split up type,
Married.
gives different version. How to appreciate that?
I had raised this point by the division bench, but
Why should the witness be
unfortunately,
believed?
unfortunately, their judgment could not be delivered at court number 5. I had taken this point. If at least for appreciation, that is his conduct, we cannot rely upon, because the Evidence Act is completely silent on that. how you can rely upon the evidence of a witness who has been examined in the other case.
No, for the purpose of giving benefit of doubt,
Yes,
can it be used or not?
yes, for appreciation. That was my submission before the court, but suddenly my lord was elevated and it could not judgment could not be delivered. Whatever, but on merit also we have got a case. My lord, we see the evidence of PW6.
No, that I would like to enlighten about that.
My lord,
The same set of witnesses
my lord.
in a split of
I'll,
trial takes a complete different stand.
my lord,
What will be the evidentiary value of because ended up an acquittal
my lord.
in so far as the other
My
accusations
lord.
are concerned.
I will come to that, my lord.
we'll see.
PW6, my lord, is the evidence of
PW6,
PW6.
yes. Then?
Here, PW6, my lord, one thing, my lord, and they can see from the affair that while deceased was returning, Nakuro Patnaik was returning from the field, on the way he was assaulted by these accused persons, those were 24 in numbers.
Hmm.
Though affair, my lord, 4 persons have been named, but charge sheet has been submitted against 24 persons.
Yes.
But on the perusal of the evidence of PW6, it will be seen that they were called by deceased to accompany with him to the field.
Okay.
So, case was just on.
Hmm.
It is alleged that while Nakuro Patnaik was returning, Nakuro Patnaik is the deceased, while he was returning from his field after completing the work around 6:30, the villagers of the Sahara community, they came from other end, assaulted.
Hmm.
No reason. They say political, some says political dispute, some says enmity was there. And here the witnesses, what peculiarity of this witness is PW6, 7, 8, and 9, those who have been posed as witnesses to the occurrence, and their names have also appeared in the body of the first information report. They have not volunteered themselves to be examined that we have seen the occurrence. Police had come on that very day to the village. They say we were in our residence, but we have not gone to the police to say that we have seen the occurrence. PW5, who is the informant, he has not said how he could know. He has not seen the occurrence. How he could know that this PW6, 7, 8, he has not named 9. They are the witnesses of occurrence, and who said him so? Because it's a criminal case, and all the criminal cases based on appreciation of evidence, and it's a case of 3. It was a case of 302, now converted to 3041, and law is very clear. Must have used it, and since the number of judgments are there, foul of the crime, hide the proof, or the graver the offense, stricter is the proof. Here, accused persons were facing trial in a case of 302, where conviction, if it would have been believed, it would have been death sentence or it would have been life sentence. So prosecution should be cautious and conscious about that.
Yes.
Here, my lord, prosecution has not attempted to say from whom PW5 has ascertained that these are the witnesses. They have not said that we have said anyone.
Yes.
On the next day, police came and police examined us.
Yes.
And even my lord, on this background, the case will be accepted as it is. They say deceased was assaulted by Panu, Raghunath, Rabbi. But let me see that they have said categorically. Well, evidence of PW6, paragraph 3-4, say, my lord, I have sorted it out.
These accused persons have.
Onnamo, my lord, Onnamo Nayak put his gamucha around the neck of the Nakula and pulled down.
Yes.
Nakula Patnaik fell while he was getting up, accused Prananath Chwar Singh, Panu.
Yes.
gave a hammer blow on the left leg of Nakuda below the knees. When we tried to interfere, accused Raghunath gave an axe blow on the right thigh of Nakuda Patnaik. The accused Rabbi Naik, Uday Naik, Biju Sethi, and Kanhu Naik assaulted on the back of Nakuda by means of their lathis. These are the persons. I have started in this way: Onama, Panu, Raghunath, Rabi, Udayanath, Biju, Kanu. These are the persons, my lord. My lord, if my lord will see Onama, I think my lord is dead.
Onama date.
Right.
Yes.
Panu not tried.
Maybe Panu might have been tried in the split up case.
Panu, yes, not split up. Panu has been tried by.
Here 15 people were tried. Panu was not one of them. Who else were tried in the split up trial?
Rabbi Naik, who is poor. Onama, Panu, Raghunath, Rabbi. Rabbi not tried, but here he has been tried and acquitted.
Only in the split up trial, who has been tried?
Rabbi, Bhagirathi Chalan Singh,
Bhagi,
Hadia Naik.
Rathi, Hadia.
And I'm told some other persons have also been tried in another case and they have been acquitted.
How many accused total?
44 persons were charge sheeted.
Unless we have the entire thing, is very difficult.
That subsequently, whether they are the statements given by them or the so-called this PW6, 7, 8, that will be considered in.
No, you said 24.
Because I have not yet brought through any additional affidavit or anything.
No, that's that apart for the purpose of appreciation only.
Madam.
You said 24 accused, 15 were tried in this appeal,
Madam.
where the appeal is arising out of, and 3 name you have given.
Madam.
So what about the other people?
That may not influence. Well, I can ascertain it from the person.
So you tell me, see, out of 24 people, how many trials has taken place?
Out of 15 persons, those who have placed trial court has given a complete go-by to 5 because all the witnesses said they were not there. But they were just seated. So, 5 janako without anything, 5 janako na cover kari kari trial.
In this case.
In this case. Au jo 11 janako, ଦେଖୁଥିଲି ଯାହା ସେଥିରେ out of the lot, not tried, Panu not tried, Raghunath not tried, Rabi not tried, Biju Sethi not tried, and this Kanhu Naik.
No, once you say not tried, it means not tried here, but in the split up.
Yes, out of this not persons not tried, I'm told Panu and Rabbi Naik has been acquitted here in this case.
Rabbi, Bhagirathi and Hadia.
Hadia, Bhagirathi has not been named by PW6.
Whatever they have been acquitted. But what about the other people? Unless the entire thing is there, it's very difficult.
Unless if you are certain.
Similarly, PW7 has also taken name of Onama, who is dead. Panu, not tried. Nidhi Khalil Singh, who was not tried. Raghunath, not tried. Udiya is dead. Kanhu, not named in the affair.
Okay.
Similarly, PW8 says Onama, who is dead. Panu, not tried. Nidhi, not tried. Raghu, not tried. Udiya, dead. Rabi, not tried. Biju, not tried. This PW8 has also not stated before the IO about Nidhi, Pratula, Udiya, Rabi, and Bijodi.
No, what I'm trying to emphasize is, if these eyewitnesses have taken the name of, suppose, 10 people, and out of 10 people, 3 or 4 of them have faced the trial in the split up trial, and they have been acquitted, relying upon the same witnesses.
Yes.
If they are acquitted, then why the other people who have been tried here shall not be acquitted? That's what I'm asking.
I was verifying, my lord. Out of the witnesses, 6, 7, 8 8 and 9, 7 and 8 could not be examined. It is mentioned in the judgment as because they were dead.
Yes, it's all right, no problem.
But 6 and 9, they have been examined, but all hosted.
In that split up.
This, I have
Hmm.
the position I have given there.
Yes. Can we get the judgment up for the other split up? Get the judgment. If those people were acquitted, whose names are being taken by these eyewitnesses here in this trial, the benefit has to go because there is a judgment. It has culminated to a final judgment, which attend finality. If the benefit is given to the other accused person whose names are taken here, that benefit directly flows to you. The investigation is completely bossed up. I have seen it. It's very difficult to sustain conviction. And what is the period undergone? Because 302, these people might have
302,
undergone some period.
I will verify.
So get those judgments there.
For sorry,
Give it back. Give it back. No, he's PW1. भैया PW1 in other trial. इसमें PW1 लाओ इसमें only 7 कर रखे. PW1 1 to 5 निकाल दो. So the judgment in the split up trials, if you give
One judgment is with me, where Rabi Nayak has been named by all the witnesses 6, 7, 8, 9. He was facing trial and he has been acquitted.
I put it in Tuesday then.
Tuesday. Just like Tuesday.
Tuesday.
16 ballot. That case which my associate was arguing with regards to injury sustained by throwing of acid. This is also a peculiar case. But the reference is there. Criminal Division number 393 of 2000.
Criminal revision. Is there a reference? 3. What is that?
Dr. Janisha?
Flag D, that the the trial court order of the confirmed that in the result the criminal division is allowed in part, the order of conviction passed by the trial court and confirmed by
The trial court convicted Chinta Morandi for offense under section 307 IPC. Came in revision, it seems. The revision court has now
that is the Chinta Marandi.
it is confirmed. The conviction is confirmed, and section 4 benefit is given. That revision order. What is the bearing on that?
The revision order filed by the Chinta Marandi.
Chinta Morandi. How it is relevant?
Yeah, I guess.
Karunakar, Niranjan, Jayadev, Vasudev.
उद्दोळा केस
आधारित
कनेक्शन नाही
Huh?
असं କିଛି କନେକ୍ସନ ନାହିଁ ଏ ଉଦୋଳା ଏଇଟା ବଲାଙ୍ଗୀର
ଏଇଟା ବଲାଙ୍ଗୀର ଏଇଟା ଉଦଳାର କେସ୍ ଟା
Why this is then?
କଣ ତାର
Shall I ask for a file? File?
नहीं देखो देखली
I'll get it from the registry. Get the file now. Just 10 minutes. After 10 minutes, we
Mal.
assemble. Let him get the file.
Mal.
Go get the file.
Mal.
Revision file. And show it to sir. Okay? I'll just come after 10 minutes. We'll get the file. File. Yes. And
There is-
in the earlier matter, see in the split up trial, the same witnesses have deposed. Whether they have deposed prior to evidence recorded here or after that,
After that,
it was not confronted also.
no.
Can at the appellate stage,
No,
I was-
that is a debatable question. For that reason, I said Evidence Act doesn't provide that.
no, it can be remanded back for the only limited to the purpose of
I was ascertaining in between.
Hmm.
They say a trial is going on with regards to 3-4 persons. Same witnesses have been examined. They have also taught hostile. Trial is going on, and one trial that Panu, main accused,
Hmm.
he has faced trial and he has been acquitted.
And Rahul also acquitted. So
Rabi
is acquitted.
Naik,
And,
he has also been.
Bhagirathi or
Raju Naik or Rabi Naik, he has also been acquitted.
And all these trials are after the trial.
Yes, after the trial.
Therefore, it could not be confronted, obviously. Okay. Yes.
Here, appellants, there are 3 in number. They were placed under trial along with the other 3 persons in the Court of Additional Sessions Balangir, being charged under section 326, 307 and other allied offences. After due consideration of evidence on record, the London Trial Court was pleased to acquit 3 accused persons and convicted the present 3 appellants.
Yes.
If the prosecution case will be accepted as it is, the affair and the statement of witnesses, the occurrence has taken place on 28/3/93 out of a petty quarrel.
Yes.
Pertaining to a land matter. And if the case will be accepted as it is, the lady accused, Bhargavi, is the person who has given that acid to 3 of his sons, those who have used it.
Karunakar, Niranjan and
Karunakara, Niranjan and Hadudev,
Hadu.
the 3 sons of Bhargavi. It is alleged that Bhargavi was called by the sons. He came with 1 mug of acid, handed over to Karuna. Again returned back with the empty mug, came with another mug of acid, handed over to other sons, and they used it. If Bhargavi has been acquitted, if the root is not there, how the fruits will come?
Right. Let us see the
But I'm coming to that. I'm just drawing the points, key points, madam. I was verifying the London Trial Court has made up his mind. Around 30 years back, I had gone through a judgment of Honorable Justice Reddy, Niranjan Reddy or something, that I believe I convict. That is the principle of criminal law. If I believe that the occurrence has taken place, there are a lot of judgments to convict an accused. If I disbelieve, no, this occurrence has not taken place, there are a lot of judgments on either side to acquit. Here, the analysis of the London Trial Court, if I will see the judgments, he has analyzed the evidence in a piecemeal way.
Okay.
Evidence pertaining to Bhargavi was analyzed first in paragraph 5. Why let me see?
Para 5.
If that will be taken into consideration as it is that, yes, Bhargavi is in no way connected with the case and that has been exaggerated or
Then the entire basis goes.
entire basis goes by. And here also, my lord can consider the settled position of law which I have raised and my lord has also observed in many judgments. Prosecution should come with a true picture of the case. It may be ended in acquittal, it may end with conviction. So prosecution should come with a clean hands. That is the language used by the apex court in many cases, and clean hands. Here, the occurrence has taken place, yes. But there was a counter case. Accused persons have also been assaulted by the accused persons, by the prosecution party. Affair was lost. They have been examined on police requisition. Doctor who has been examined as DW1 has said that I have examined these witnesses on police requisition. As because police being endeavor or whatever it may be, for the occurrence on the same day, within 4 hours, they have been examined on police requisition. But affair was not accepted. Requisition was there. Doctor says on police requisition, I have examined them. IO says I have sent them to outpost, but I have not received, not given any requisition. In the cross-examination, PW10 says
There is no registration of FIR according to.
Yes, and complaint petition was filed. Complaint petition cognizance was taken. I don't know what has happened in that case, but Karunakara and Niranjana, they had received 5-6 injuries. And I was going through one of the complaint petition, which has been exhibited as Exhibit C. There, the entire case has been explained in detail. Fact that, my lord, the present appellants have got a jewelry shop, small jewelry shop in the village. They had, the prosecution party had assaulted them, chased them, and Adhikanda Joshi, who has been acquitted, who was an accused and acquitted father of the present appellants.
Yes.
He says, he is the complainant in that complaint petition. He says, my sons were assaulted, they were chased, and they came to our jewelry shop. There, when a sheet was there, the attempt was made to put a sheet to my son. It has been, they have attempted and succeeded. There was a fracas and they have received injuries.
Okay.
That is there in the complaint petition. There are also case of 3026 and 307.
What happened, nobody knows.
My lord, yes. Again, question comes up whether witnesses have stated so. Well, the question has been put to the witnesses. I don't know, my learned friend must have marked that or has not marked that. Question has been put to the witnesses, and witnesses tried to explain the injuries well.
Okay.
Prosecution, as it is in 161 statement, it was not there. When it has been put in cross-examination, he said, yes, there was some load and he must have received injuries by that.
Okay.
My lord may see, before going to that, I just want to draw my lord's attention to evidence of W3, page 75. He has candidly admitted certain things. I would just want to draw my lord's kind attention to that.
Yes.
Paragraph 4.
Yes.
Page 75. I know Annapurna Joshi. It is a fact that there is a long-standing dispute in between Adhikanda Joshi, accused acquitted, and said Annapurna. Annapurna was claiming herself as second wife of Adhikanda. Excepting Adhikanda, other male accused persons are sons of Adhikanda. I do not know if sons of Adhikanda, who are accused persons in this case, have filed any petition suit as present
As against
Annapurna in the court of Sub-Judge Balangir. I do not know if my father deposed in that case in favor of Annapurna. It is not a fact that I have bad terms with the accused person since the days of my father. There is a case against me and 7 others instituted by Adhikanda regarding throwing of acid of the same day, on the same day. It is a fact that they have alleged in that complaint case that I myself and other witnesses in this case have gone to assault these accused persons being armed with lathis and threw acid to Niranjan, accused, and transacted and ransacked his properties, including golden ornaments and cash, and assaulted accused Niranjan by breaking his head. I cannot say if Niranjan and the Karunakara laws report at the police station with that allegation. This was not there in their prosecution case manner.
Okay.
Prosecutions cannot suppress genesis of the case and come with their own and
Where is the injury
getting
report?
over ASI. ASI
Where is the injury report of Niranjan and
pilot. Yes.
let us see.
Exhibit A.
Karunakar?
Exhibit A, that is also pilot.
Exhibit A.
My lord, I was medical officer, but that is at page 117. I was medical officer at additional PSC,
1 minute.
Bandhapada of district Balangir in the year 1993. On 28/3/93, I received medical requisition from police to examine Karunakar Joshi and Niranjan Joshi. I examined them and found some injuries. I examined Niranjan Joshi on 28/9/93, 28/3,
Which is there in the paper.
393 and found the following injuries. Lacerated injury on the size 3 inch into 1 by 8 inch.
No, are you reading from the paper book?
My lord, 117 page.
Page 117, there is the
117.
The position DW1.
That's 17.
He has received 6 injuries, my lord.
Okay.
Lacerated, bruise, multiple linear abrasions, bruises at the size so and so, burn injuries, multiple burns.
all the applicant injuries.
Very simple.
No, simple. No.
Question of simple.
ये burn injury is there.
My lord.
Acid burn injury.
Yes, man. Engine number 5. Burn injury of size of 1/4, 1/4
Right
right
chest.
chest, 3 inch below posterior axillary fold. Multiple burn of size of 1/8 inch and 1/8 inch.
This is very important.
Very important one.
Why I'll tell you. If he was using the mag to throw the acid, it would not have injured his chest. That means the injured in this particular case might have thrown the acid on Niranjan also. That is their case.
Yes, man.
Niranjan also. Niranjan and Karunakar.
Madam. Injury is there, but
Both of them kept throwing acids
that is the allegation.
on each other.
They have come with
Yes,
one
so
case
in
and
the
my lord,
what-
peculiarity. My lord, we see the peculiarity of the case. How IO has been managed. ASI, a police. I'm drawing my lord's attention to that.
When the incident took place,
On 28,
14,
28, my lord. Same day when
28.
FIR was registered,
29, this 28th only this.
28 has been examined, my lord. Within 6 hours.
I received medical recognition. Yes. Yes.
The age of the injury was within 6 hours, my lord, page 118.
Hmm.
At the time of my examination, exhibit 8 is my report. Let me see.
There is
Page 115.
1,
15.
115. Yes. Yes. Ayo.
I said Niranjan,
Which paragraph?
page 115 beginning.
Yes.
madam.
I sent Niranjan and Niranjan to
PSC for a medical examination, but I did not send medical requisition. I did not send Karunakar for medical examination. Why? If I have received injuries, I had gone to police station, outpost,
And the doctor says that requisition was.
yeah, medical requisition. That is they have managed, but in that way, ASI or police was managed in that way.
See, I did not send Karunakar for medical examination. The medical report of Niranjan is not available on record. And it is not a fact that I send Karunakar. to
But doctor of the
also
PSC says I have
for medical
examined.
examination. It is not the fact that CEO means to accompanied by the Karunakar.
And the doctor is additional medical officer, additional PSC.
And the medical report of Niranjan.
But the Schedule 1 stated that I received the medical application from
Huh.
to examine the Karunakar and
That's what we are saying.
That-
sir.
And peculiarity ballot, this fact has not been touched by Law and Trial Court.
Not at all touch.
Not at all touched. And these exhibits have not been considered even. A, B, C, exhibit A and B, the injury reports, and C, the complaint petition. That has not been touched. Yes, there will be, if there is a case, there must be a conviction, that must be accused person should not be left unpunished. But that doesn't mean that we will totally ignore it.
This report is exhibited.
A, B and C, the complaint
Where
petition.
does it say? Where to?
A. Verify कर सकते
Where the witness doesn't say that.
Mallet?
Exhibited.
Mallet?
What does it say? The witness says.
That has been exhibited.
The report is.
Report is
sent to
exhibited.
ASI.
Mallet, yes.
Outpost. No, where is the exhibit B?
B is Mallet and 118.
Hmm.
Exhibit B is by report. The age of the injury was within 6 hours. At the time of my examination, exhibit E is by
Exhibit A.
report.
This is not considered. Exhibit A and B.
Has
are
not
the
been
extract of the original report. And in the end, signed in the bottom by exhibit B, so and so, in fact, this and so. Yes.
And I will say PW8 ballot may see informant.
PW
8.
informant. Yes.
When this has been put in cross-examination, what he says.
Yes.
It is not a fact that I did not state to the IO that Karunakar took the bog and went to the
Which paragraph?
ballot, page 96,
Hmm.
paragraph 4 towards last.
Yes. Yes. It's not.
The same mog,
I did not
Karunakar
state
threw the
the IO
acid to
that,
Saraga, which fell on his left shoulder and on the right thigh, and some part of acid which also fell on his chest.
Where is that you call?
That he tried to explain.
Yes. I did not say to the IO that Karunakar took the mug and went to his mother and poured acid.
Who poured
in the
acid in the same
same
mug,
mug.
and Karunakar threw the acid to Saranga, which fell on his left shoulder and the right thigh, and some part of the acid on the fell chest. And that Karunakar gave the bog to Hadubandhu, who took the bog and brought the threat from one mother. It is not a fact that I stated to the IO that being hot by acid, we left the spot, so and so. The hearing of the case was, he has admitted, Ashok Joshi is my father's elder brother's son, Gopinath Joshi so and so. I do not know if Gopinath was acquitted in the case. The hearing of that case has not begun. I cannot say if Niranjan received head injury at the backside of the house of Adikanta on the same day. It is not a fact that I am not pulling and well with the accused person because of the old enmity since the grandfather, Chandrasekhar Joshi, so and so.
Yes. Who is the doctor?
Doctor is 4 and 5. 4 and 5.
Let us give 4.
The law is very valid in
Fine.
that respect. This should come. Yes, there was an occurrence. There was some sort of injuries.
5 let us see. Corrosive burn.
On 1892-93, I was attached to the district headquarters hospital. The assistant surgeon on that day, I examined the Saramudar Uttan, son of surgeon and found the following injury. One portion born on intermediate area of the entire chest and leg. Second portion born on the inferior superior aspect of the entire chest with the intermediate healthy area. Portion born in the intermediate area over the left upper limbs, left shoulder and left scapular area.
The injuries sustained by the witnesses, prosecution witnesses are admitted. But if their case will be believed, our mother has given the bog with acid.
Mother is out.
Mother is out. If mother is out, the bog is out, acid is out.
No,
Rather the second case is more acceptable. There must be a fracas there in the shop. And they have received injuries. But if the prosecution, but they should start on their own legs. And
if PW 4 is the doctor.
If the genesis
the-
of the case is doubtful, how the case will stand on the lame leg? And this Taravani Hota, the
How many injuries are there?
3.
4% are.
No,
And this Tarangani Hota, her presence has been disbelieved by the trial court. PW1.
Saranga is PW?
The Tarangini Hota.
Yes, Saranga.
Saranga is PW. My lord, Saranga PW9, my lord.
Trial court order is right.
PW9 is at page 102.
Saranga is PW
9. my lord.
9, huh?
Right.
8.
Again?
9.
9.
Nine.
PW 9. Tarani is PW. Tarangini is PW 1.
My lord.
PW.
Well, before this, going to the evidence,
Suraj
if my lord
Joshi.
will see the observation of the law and trial court in in paragraph 5, everything will be clear. How they have developed the case.
We did that. Just doctor's evidence and let him. Jagdish is Jyotish Hota. Jyotish Hota is PW 2. PW 2. Then PW 2, PW 8, PW 1, and PW 9 are the injured.
Injured.
Okay.
1, 2.
Hmm.
And so for the mother who has acquitted, that part of the deal in the judgment copy, internal page 9, page 17 and 18.
Nah,
Paragraph
5.
I prepared the aforesaid report of the revision ticket. I cannot say
If this part has not been accepted by the trial court, then the entire case goes.
not that,
They have not challenged this.
there is contradictions, some of the evidence, that's why the implication of that mother is the
Mother and 2 persons, 2 other.
page 8. Then on page 8 and on page 16, that paragraph 2, that is the married.
1 minute.
Paragraph 5 टा पढ़ो पूरा जड़ा पड़ जाओ. Yes. से part piece पे पढ़ा जाओ.
Yes. Let us read para 5 then.
Para 5.
Para 5. Yes. Let me come to
Let me
analyze.
now come to analyze the evidence of
Let me
as against each
and
accused.
comes to analyze the evidence as against each accused person and to examine if the evidence of the sufficient to sustain the charge against the each. This decision will be
This section.
will make easy to meet the end of the justice. For this reason, I want to take up the evidence available against the lady accused. Marvel. One had not stated to police that story what she did. Because right from the stage of calling the 5 gentlemen by Tarangar to solve the problem, he issued a term on or by Habude. This is apparent from her statement at paragraph 5, where her previous statement was confronted to her. In this connection, defense has also cross-examined the investigation officer who because at paragraph 12 that we told what did not state to him that Bhadralok came and they supported Tarangar and the male active person did not listen to him. They sent Tarangar to kill him and the IO before that did not state to him all the subtle events as stated by her in her till acid was thrown to her by accused. The role played by the accused Bhargavi was also not stated by these witnesses to the investigating officer, who is one of the evidence of the event of the incident stated by her in the chief. Hence, on the point of contradiction, the evidence of Federal One should not be relied on the interest of the accused Bhargavi. The reason of the associate huge contradiction in the evidence of the Federal One is that she reached the spot at a later stage, which is apparent from the cross-examination, Federal 3 at paragraph 7. Here the witness stated the same as Sonamaji and the Gandharva Pradhan, the two were the servant of the Sarangara, Ramesh Sarangara Joshi, and some small children were present at the spot. The accused person when he and other Bhadalok reached the spot. So he did not say that Fidul One is present at the spot when Bhadalok reached at the spot. Therefore, Fidul One did not state to IO anything from the very beginning of the occurrence. He still was told to her. Now let me go to the evidence of Fidul 2 to can if he had implicit active aggravated and in hard manner. Fidul 2 was at paragraph 1 there. Karunakar and Harudev asked their mother to bring a acid and thereafter Bhargavi came with a 2 bottle with acid and mug. He further disclosed that Bhargavi poured the acid in mug and Niranjan took the mug and threw the acid to the face of the Sarangara. He added that Niranjan thereafter gave the mug to the Bhargavi and again she poured some more acid.
But if this
And
part,
Karunakar
if we take it into consideration, if Bhargav is not in the picture, then how this acid with
Same.
mark came to the spot?
that mug which acid and through the Sarangara, which fell on the right hand and left shoulder, and some part of the acid also fell on the Saroj Kumar Joshi, Hemant Sonamaji and Ramesh Chandra Kostar, who were the standing behind the Sarangara. The witnesses of disclosed that Karunakar have a mug to Bhargavi and she again poured acid in the some mug and Harudev brought the mug with acid. This evidence will to show that Niranjan, Karunakar and Harudev had gone to the Bhargavi
Brought the AC.
acid. This witnesses did not stated to police the Niranjan gave the mug to the Bhargavi who was the poured more acid in the mug and Karunakar took the mug with acid and threw the same to Sarandar, which fell on the right hand and left shoulder and also some part of the acid on Saroj. He Utkant and other were standing behind the Sarangara and Karunakar gave the mug to the lady accused, who again poured some acid in the mug and Harudev brought the mug with acid. It is the assertion from the IO. As paragraph 13 by the defense, who did not state this to him that Niranjan gave the mug to Bhargavi, who poured some more acid in the mug and Karunakar took the mug with the acid and threw the Sarangara, which fell in the right hand and left shoulder and some part of the acid also fell on Saurabh, among the Sona and Ramesh, who were standing behind the Sarangara. And that Karunakar gave a mug to the lady accused, who poured some acid in the
Same mug
same
again.
mug again, and Harudev brought the mug with acid. This contradiction also elements from the portion of the allegation against the lady accused about her role played in the waiting the
Edit the contradiction.
to prosecution case. She had supplied acid to the Niranjan, Karunakar and Harudev, who took the acid and to the injured person. Now let him come to the evidence of the pedophilia. He did not support the pedophilia that Harudev asked his mother to give him the acid. These witnesses had simply implicated the accused Karuna, who asked his mother to test acid and thereafter to the lady accused for the acid and poured the mug which Niranjan took and to the face of Sarangara and gave him the mug to the mother Bhargavi, who again poured some acid in the same mug and gave the mug to Karunakar. Accordingly, Karunakar took the mug from his mother with the acid, but according to the 3, the lady accused poured some acid in the same mug and gave the mug to the coroner. Then there is a contradiction whether the lady accused gave the acid mug to the coroner or accused coroner took the mug from his mother. Defense confirmed the previous statement of Schedule 3 and brought the contradiction at para 2 that Schedule 3 did not state to IO that the lady accused poured the acid in mug which Niranjan took
After
and
throwing the
after
same
look and after throwing the same to Sarandhara, he gave the mug to his mother, lady accused, who again
or some acid
poured
in the
some
same
acid
and
in
gave
the
to
same
the
and gave
Karnataka.
to the same Coroner, and lastly, after return of the mug by Coroner to her, she pours more acid in the mug. Rather, Schedule 3 stated IO that when the Schedule 3 was explaining to the Coroner, Niranjan handed over the mug to the Coroner, and he stated to IO that Niranjan snatched away the acid mug from the Coroner and threw the same. As a result, Sarandhar, Schedule 1, Schedule 2, Saroj Kumar, Ramesh Gupta, and others sustained injury. This is also assumption from the evidence of the IO. Schedule 10 at paragraph 14, Schedule 3 did not state to the IO that the lady accused pure acid in a mug which Niranjan took and threw it to Sarandhar and gave the mug to his mother Bhagravi, and that the lady accused poured some acid in the mug and gave the same to the coroner who threw the acid from the second time. And after return the mug by coroner to her, she poured some more acid in the mug for the third time. Now let's come to the evidence of Schedule 8 about the role played by the lady accused. He corroborated to Schedule 2 that coroner and Hardev called their mother to bring acid to kill Sarandhar. And in the consequence, Bhargavi brought the acid, but these witnesses added that Niranjan also demanded acid from his mother, who brought the acid from his mother and threw it the face of Sarandhara and handed over the mug to the Pranakara. He contradiction Schedule 3 by saying that he handed over the mug to Pranakara because of Schedule 3 deposed that Niranjan handed over the mug to his mother. According to Schedule 2 also Niranjan gave the mug to Bhargavi, who poured some more acid in the mug, and Pranakara took that mug with the acid and threw it Sarandhara. Now let me go to the second page of acid found by the Pranakara. According to the 8, Pranakara went to his mother, who poured acid in some mug, after which Pranakara threw the acid to Sarandhara, which followed the Sarandhara and other persons. He differed with the Schedule 3. Schedule 3 deposed that Niranjan gave the mug to his mother, who poured acid in the same and gave the mug to Pranakara. Let me go to the third of acid of Schedule 8. Before that, Purna gave the mug to the Hardev, who took the mug and brought the acid from his mother, Hardevi, and then Hardev threw the acid. But according to the Schedule 3, gave the mug to the lady accused, who poured some more acid in the mug, and Hardev threw the acid.
So I got it. See, PW2, 3, 1, 2, 3, and 8 were not believed when their evidences are juxtaposed with the IO's evidence. And therefore, the acquittal is recorded in favor of Bhagirathi. If the same witness is very elaborately analyzed, if the first part of the story goes, how will you support the second part? There should be a continuity of the prosecution story. Part of the story is not believed. And it is confronted with the evidence of the IO. All of them have stated something before the IO and they have improvised.
They are not disputing, but that's why he did not state it to the IO that Harudev and Purna asked their mother to bring AC. And Niranjan went to her and asked her to AC.
Yes.
And the lady actually poured some acid in a mug and gave it to the Niranjan, which Niranjan threw the face of Schedule 9. This is also apart from the cross evidence of the IO at paragraph 16. From all these affected evidence, I felt there are
In the end it says,
contradictions.
in the end it says, I find that there are a lot of contradictions and embellishment about the role played by the lady accused in supplying the acid
Acid.
to her sons, so and so. the evidence implicating her was only developed at the trial stage. Hence, I entertain the strong suspicion about her implication in the and hold that the prosecution has failed to prove the charges against her beyond all reasonable doubts. This is what is the finding.
And there are the four injured person that below 1, 8 and 9.
And about all of them have said that it is the mother, the lady who is given in the mug, which was used. That is the consistent story. If that part is not believed, how safe it is to convict these people? You would answer that.
Yearly,
And second thing, what he is showing is these accused persons have also received injury, and they filed a separate criminal case, and the injury, burn injury is there.
that is on a
Burn
record,
injury
because
there.
one-
And on requisition of police, they have gone. That part of the story was not explained by any witnesses except the IO. The IO subsequently comes out with the story, which was not clear in the FIR and all.
How
So
does
these things-
that when we see page 23 towards the middle by the in the judgment.
Which part? can be?
In this connection, defense cross-examined the IO who admitted that he sent
In
Niranjan
this connection, defense examined the IO, who admitted that he sent Niranjan to so-and-so medical hospital, but did not send.
medical requisition. He denied to have sent Karunakar for medical examination. It was suggested to him that he sent Karunakar also to the same PSC for his medical examination, and the medical officer sent medical reports of Niranjan and Karunakar to Bandhapada outpost through memo numbers 59, 50, 25, 394. The IO denied to have received any written report from Niranjan against Sarangdhara and others on 28, 393. It was suggested to the IO at paragraph 19 that he suppressed the report of Niranjan and Karunakara dated 28/3/93, who were present at the outpost before arrival of Saroj Joshi, informant of the present case. Of course, defense examined EW1, the doctor of Bandhapada PSC, who proved exhibit A and B, the two medical reports showing injuries in the persons of Niranjan and Karunakar respectively. Defense also examined one advocate's clerk who proved exhibit C, a complaint petition, and taking up cognizance by SDJM Balangir. It is established principle of law that evidence of each case should be weighed in independently. Say, Sarila. The case is not explanation. The answer of IO about his memory in sending Karunakar to Bandhamunda PSC for examination should not be doubted for any other reason, because of IO had no records with him to refer while answering to the questions of the defense. That's it. When the question has been raised that all the witnesses are related to each other and the presence of witnesses were there, those who have witnessed the occurrence, answer of the London trial court is, it is the choice of the prosecution to examine the witnesses on his own. Which is directly in the contradiction of the off-court decision of the Apex Court 71 Supreme Court matter 1586. It's not the choice, but these examinations, he should examine the witnesses whose examination would have unfolded the narratives. and he has relied upon a Gujarat decision and says,
Then evidence of PW 8 is now analyzed. Huh?
in permanent manner.
And these, they have received the injury, all are simple injuries?
Manner.
Simple injury.
Question of simple or grievous is not important. Important is whether the injuries are in the vital part of the body or not, and whether the plausibility of the complaint petition vis-a-vis with the injury. Because they say after assault they chased and came to the shop of the Adhikanda. Adhikanda, my
That is
lord,
the complaint. That is the complaint.
that is the
That's the
complaint.
complaint.
And yes, and in that there in the shop, because it's a goldsmith's shop, acid will be available.
That I was.
And my lord, if this part vis-a-vis with the case of prosecution, that occurrence has taken place in front of the house of the accused persons. Mother has actively participated in supplying acid in a mug, 2 mugs or 3 mugs. And that
No,
part
according to the defense, the incident happened in the shop.
in the shop. My lord, that complaint petition is there.
But what about the
Well,
prosecution?
independent witnesses were there, and the Sarnu Machi, Ramesh Hota, Hemanta Joshi, Padmini Joshi. Court says it is the choice of the prosecution to examine his witnesses. There was he should have if IOA, if they have not been examined, at least some reasons is to be ascribed. Yes, they have been threatened. They are not supporting this case. This that. But relying upon a Gujarat decision, court says it is the choice of the prosecution to establish its charge, who know that the quantity does not matter, but it matters quality of the
Quality of
that is the law.
Yes.
Evidence is to be weighed, not counted.
Yes.
From whom did the land has been purchased? May I place it on that?
PW?
8.
Yes.
94,
Saroj
94, 94,
Joshi.
94.
The occurrence took place on 5 p.m. It was the Sunday. Taramghar purchased a bari land from Bhikari Joshi. Adhikand accused also purchased a land. He house from the same Bhikari Joshi. There was a
Passage from the land of
purchased by
purchase.
the Adhikanda to the bari land purchased by the Saranga on the direction of the Saranga, son and his trade servant Honna Maji. They are constructing a wall to close that passage. At the time, all the accused person, including the female accused person, came to the spot, and the male accused person demolished that newly construction wall. Saranga came and wanted to explain that the wall was raised on his own land, but the accused person came and worried Saranga not to raise any wall, and asked him in slang language, said, thereafter, Sarang went to call Ujjola, Naik, Vrindavan, and Panidai, Kanu, Tarana Joshi, Buddha, and Southern Sir to come wanted to the intervene, saying that both the purchased the distant land from the Bhikari Joshi. The accused person did not listen to them. The Bhadraloko remained at the distance of 57 km. Thereafter, the accused person threatened to kill Saranga. Niranjan Joshi dealt a blow with a small stick on the left shoulder. Saranga, when the Niranjan was trying to give a second blow, Kanhu Joshi protected them, same by raising hand, but he received the injury at his chest to some extent due to the blow. Karunakara and Hardev called their mother to bring acid to kill Saranga. Bhargavi brought the acid. Niranjan Joshi also demanded acid from the mother. Thereafter, Niranjan brought the acid from the and threw to the test Saranga. Saranga cried
When according to this story, the incident happened there in the passage where the construction was.
Passage.
Where from the acid came?
From the house of the accused. And my lord, that was IO has stated that.
Hmm.
And they don't tell.
They were keeping acid in the house.
Yes,
Very
because
good.
of the goldsmith.
No, it must be there in this shop. The story put forth by the defense in the complaint sounds more plausible because the incident had happened in the shop.
And if that mog part will be disbelieved.
And if the mother carrying the acid from the house, if that part goes, the story goes. Your cases, prosecution cases, in the place where in the passage the construction was going on, there the fight took place. The mother brought the seed in a mug from inside the house and gave it to Niranjan. Niranjan is thrown it. Thereafter, Niranjan gave the mug to Karunakar. Karunakar told the mother to pour it once again. It was poured and thereafter thrown. This is the story you are telling. The acid they brought it from the house. Who brought it? The mother brought it. Mother's role is discounted by the trial court, saying that we will not believe that part. That part goes. In the contrary, the story put forth by defense is that in the complaint they say these people were chasing and went to their shop. In the shop, obviously, because goldsmith shop, obviously the acid was there, and there was a ruckus taken place. There was a free fight. In that process, not only these injured persons have received injury by the accused person, and these injured persons also injured the accused persons, and they have also received injury. And that sounds logical because one of the accused has got burn injury in the chest.
Yes.
If he was throwing acid,
Definitely.
there was no question of burning in the chest. In hand I can understand because you are holding the holding the.
Another thing, my lord.
So which part of the story is more plausible?
And another
They
thing.
are throwing the acid in mug. If they are throwing the acid in the bottle, they are different part. Once is the mug, the face of the mug is very wide. So some portion of the acid might have been.
That mug story is disbelieved by the trial court.
The role of the.
Then if you are saying that the acid was there in the house, it was brought by the mother, and mother's participation is discounted by the trial court, then that part where from you got the acid? Acid was there in the shop, where the place of incident is doubtful. Place of incident is a doubtful thing, whether it has taken place outside the shop or in the shop.
This has searched the house of the accused and seized that vessel. That page 109. 109.
Okay.
Evidence of the IO.
Yes.
I conduct the house search on 29/93.
109.
In the house of Adikanda Joshi, with the father of the accused persons.
An acquitted.
Accused. I seized 2 bottles, out of which one is white and other.
Which paragraph?
Paragraph 7.
I conducted the house.
I conducted the house search on 29/93 in the house of Adikanda Joshi. Accused, I seized 2 bottles, out of which one is white and other one was a grey. Both are containing the liquids. On one of the bottle, there is a level of sulfuric acid, and on the other one, there is a level of nitric acid. I have to seize one rose color plastic mug. I got this property on house search. MO3 and MO4 are the said 2 bottle, and MO2 is the plastic mug. I prepare the short list.
These bottles were sent to CFSL.
Yes, madam. Yes, madam.
Nitric acid and sulfuric acid found.
That the CO report page
It's there.
122 and 123 also.
What about the mug?
Yes, madam.
What about the mug? Mug.
The C.
Hmm?
Mug in the 100 crore plastic mug marked as C.
No.
Exhibit C.
Where is the report?
Yes, the page 123.
123.
Result of exemption. The total mark as exhibit.
123 plus 122, 123. Yes.
Total mark as a content of sulfuric acid. The bottle mark is the content of nitric acid. If the mark B, K, L, and O are found the content of sulfuric acid, if the mark M, N, E are found to the nitric acid. If the mark G, and I are found to the
Mug is what?
Mug is exhibit C, second bar. When C is found with the content of sulfuric acid, it might have been used to carry a sulfuric acid.
Exhibit C is the mug.
It's
Sulfuric acid. Yes. Who has received severe injury, grievous injuries? Nobody has.
that
Injuries are simple. All injuries, if you come to PW5,
They have given a
four. There are 2%
interesting part by my knowledge
That
friend
is the
must have marked.
PW?
Schedule 4. That first refer to Schedule 5, then refer to the Schedule 4. The Tarangin Hutta. There are 2 persons. One that is the Schedule 1 is the Tarangin Hutta. Yes, Tarangin Hutta.
Natural grievous.
Assistant Professor, VSS Medical College, Bulla, Natural Tarangin Hutta. That the Schedule 1 was referred to me for the casualty on his subject 1690 for my exemption. She was a indoor patient of VSS Medical College, eye department. She was admitted in the bed ticket of surgeon. She had sustained the SD1 face, shoulder, right arm, and the right from arm. The burn was about 50 to 20%. What do you mean by percentage? The entire body is taken the 100% and the extent affection is taken. She had injury on her upper limbs, right side of the face, with secondary injuries. The age of the injury was within 3 to 4 days. The nature of injury was the grievous. Exhibit 1 is my report. And
Yes, I got it. I got it.
On the same day, I also came to Sarangarhola. That is the PW9.
Taranga, both eyelids of the patients were with extensive acid burn and developed contraction and the permanent deformity.
And it my lordship
Found the
the
secondary
PW4
infection.
report. That is the second page. On the same day, on 7th, I examined the Tarangin Hota. One is the portion born entire face with a small area of the healthy skin of in between. And 5 is portion born on the its eye, causing congestion of the condition and the corneal.
She was admitted to casualty and then shifted to I ward.
And as and the PW5 also 4 also dated as a report for plastic surgery. 82.
Yes.
And at that time, the Schedule 1 that is the Tarangin Hota, the age of 22 years old.
Yes.
And so far the 313 statement of the accused. ସବୁ ଜାଗାରେ ମୁଁ ଜାଣି ନାହିଁ. And if my lordship has question number 13, it is further transparent from the evidence recorded that you co-accused person to the SCD to the PW 1, 2, 3, 8 and 9. Hemanta Sona Maji and Ramesh Sutta causing an injury. What do you say? ମୁଁ ନାହିଁ ଜାଣି. They are not defend that.
Yes. Yes. Yes, sir. Anything?
And here, PW1.
Hmm.
If the evidence of PW1 would be believed, as it is, well, she has implicated all the 6 persons.
Yes.
And each accused persons have been ascribed role individually.
Hmm.
But the in trial court, on an analysis, discarded her evidence pertaining to 3.
Adikando and
Adikando,
lady,
Bhargavi and Jaydev. Discarded. And this witness was examined by the investigating officer around 12 days of the occurrence, 12 days after the occurrence. Well, let me see the evidence of PW10.
Yes.
PW10. He has examined PW1
After 10 days.
after 10.
Yes.
That is where I examined Tarangin Hota on 10/5/93.
There was a reason because she was hospitalized.
No, my lord.
She was terribly.
Not that, my lord. She was unable to speak. My lord, a person who is unable to speak, he or she cannot be examined. But injuries are on the bodies.
And also I.
ଆଇଟା ତ କ'ଣ ପାର୍ଟି ସାଙ୍ଗରେ ସମ୍ପର୍କ କି? My lord, and if this statement will be, can my lord, it is always law, it's very clear, my lord. Admittedly, the witnesses, all the witnesses, including the injured witnesses, they are all related to each other.
Because admittedly, there was a dispute.
Landed dispute.
Yes.
So they are inimically disposed of as well as they are interested. On the face of it, most of the witnesses, including the investigating officer, has admitted number of independent witnesses were present at the spot.
Yes.
Number of independent witnesses were present at the spot. So when the witnesses are inimical and
This is 2 to 3 gentlemen came to the spot.
yes, but why they have been they have not been examined. My lord, when these witnesses are related, interested, and inimical because of the marriage, second marriage, first marriage, Adikanda, that is admitted by PW3. So 3 things are there. At this, I'm quite conscious about the proposition of law. Witnesses are interested, inimical, and even my lord injured, maybe injured, my lord. Their evidence is to be, their evidence require some sort of corroborative evidence with them to accept it as it is. On the face of a defense case which competes with the prosecution case. Not that accused persons, appellants, they have not received injuries. They have, as it is on the last occasion, my learned friend submitted while my associate was arguing. Yes, if it would have been a plain, simple acid throwing case, definitely, my lord, court should take a very serious view of the matter in view of the recent judgments of the apex court. When the case is shrouded with this type of addition, embellishment, or exaggeration, what is the duty of the court? Whether to accept this evidence as it is, or the court will need for seek for corroboration. What is the corroboration? What are the corroborations prosecution has given? Rather, the answer given by the law and trial court has not explained under what circumstances these injuries have received by the accused persons on the same day, and why police officer has suppressed the requisition, or why the affair was not registered, why adverse view will not be taken against them. That has nothing been said.
Yes.
Again, the major part, because the prosecution starts with giving up acid to the accused persons, even not once, twice, thrice, the accused who has been acquitted, who is related to the
You can
appellant.
put it like this: the weapon of offense, that is the issue.
Yes, that has been that.
That is doubted.
And
the source
another
is doubted.
another important
Yes.
fact which my learned friend has not submitted, I have not drawn my lord's attention. All the witnesses have stated, in one hand the accused persons were with a seat box, the other hand they were with a stick, a shimel stick. Shimel stick, when I was going through the dictionary meaning shimel stick and medical evidence, they say it's a stick which is full with Felix pellet. That not a plain stick. Rather, the appellants have received injuries in that stick. Rather, when in the case of Exhibit C will be considered, the accused persons were the prosecution party, where those who are accused persons here, they were armed with that cement stick. They had come to the shop with a cement stick, assaulted. May let me see the injury report at this juncture. Exhibit A.
Injury of DW1.
Yes, madam. May let me see.
Yes.
Lacerated injury of the size is placed in over the middle scalp, bruise, scalp mallet. It's not a mallet. I was drawing my lord's attention to a judgment long back when I had argued the case Krishna Podo versus State. In simple injury, half inch into 1/4 inch and 1/4 inch, a case of double murder. Honorable Justice Prasad sitting with, I don't remember the second in a division bench, court has disbelieved, relying upon 76 Supreme Court 2263. Here, my lord, the lacerated injury is the size of 3 inch into 1/8 inch and half inch, placed over the middle scalp, bruise of size of 2.5 inch into 1 inch, placed over the posterior side of the right arm, multiple linear abrasions, 2 inch length, each placed over the posterior part of the right shoulder, bruises of the size 2.5 inch into 3/4 inch over lateral side of the upset part of the right thigh. All the aforesaid injuries are simple in nature. Injury number 5 and 6 might have been caused by caustic agent, and injury number 3 might have been caused due to sliding over the hard and rough substance. And other injuries might have been caused by hard and blunt weapons. Injury number 1 and 3 might have been caused within hours of my so-and-so. Injuries might have been caused within 12 and 1. Here, under these circumstances, I want to say they were initially, that is the complaint case. The accused persons came being armed with lathis, and whatever that acid, throwing of acid or use of acid, that was in the shop. And with the role of investigating officer by seizing mugs, seizing bottles, it is telltale because he from the very day, he has not accepted our affair. Though he says, I had reached, Niranjan had reached earlier to PW8 in the police station. He had not issued my medical requisition. The reasons best known to him. And I was going through, he's not a senior officer, he is ASI of the outpost.
Yes.
And that is the conduct of the investigating officer from the day one.
See, insofar as Niranjan is concerned,
My lord.
On 28th only, he was examined by
My lord,
PW1.
my lord,
And he was not fully examined on that.
my lord,
Next day again, he was called.
my lord. No,
And
no,
when
the
he
reason,
went along with
the reason
Corona-
ascribed, my lord, see this.
See, the court question,
Yes.
why did you examine?
Why did you
patient?
examine the patient on 2 dates?
Two
I
days?
examined.
And
the-
he explained, there was no light and all.
I examined the injury number 2, 4, 5, and 6 on the following day, that is on 29/3/93 at 8 a.m. to get sufficient sunlight to ascertain the color changes of those injuries to give my opinion. Since there is no there is insufficient light in the previous night to examine the color of the injuries.
On that day only, he examined Karunakar
Madam, I examined Karunakara
on the 29th.
on 29 and found the following injuries, abrasions, so and so, caused by slide over hard and rough substance. Injury number 1 might have been caused by pinpointed light object. That is the that injury is symbol, that weapon that caused that stick can cause this injury. Pinpointed injury. But these accused persons, whereas the prosecution party so-called injured, they have not received any stick injury.
Yes.
But they have stated in their evidence, my lord may say.
They were holding it. I have seen that.
My lord, civil.
I have seen that.
That shows prosecution has not come with a true picture, true story. There might have some occurrence, but the way the prosecutor has put his case, that is not the way.
It looks like a free fight.
Yes.
Free fight.
My lord.
Free
Yeah,
fight.
yeah,
Both
prosecution,
sides
my lord,
received
yes.
injury. Both sides received injury, and the place of occurrence is somewhat bit doubtful because of
Crowded with
the
mystery, my lord.
findings of the trial court insofar as Bhargavi concerned.
My lord.
That part of the story is not believed. So
Crowded with mystery.
exactly where the incident had happened.
Not fight
Not coming
place,
forward.
but the way the prosecution has put forth the case, that
They
now,
filed a written note of
my
submission.
lord, I will give it to you.
Wanted judgment review.
By Thursday, my lord.
47. 40. Then the thing of order. Very outline for and so on. Filed the note of submission. Nice.
Item 29. 29. Conviction is for 2 years under section 325 and section 323 for 6 months running concurrently.
Yes.
The facts of the case is there was a family scuffle
Evidence.
and the accused is the cousin grandson of the opposite party, the deceased. According to the informant,
Who is informant?
informant is PW3.
Come to informant. Yes.
Accused Kesab in dock is the son of the brother of my husband. This is Sada Nayak, was my father-in-law. The house of the accused is in front of our house. They're all family members. 2 years back, at about 10 p.m., Gandhia Nayak, my brother-in-law, quarreled with deceased. The one Gandhia Nayak and the deceased Sada Nayak were fighting verbally. I admonished Gandhia why he always quarreling with the deceased. The accused
And
came carrying a jewelry yoke. It's a wooden plank, wooden bar suspended above the ox or buffalo for used for farming purposes. That and poked on my belly. At that time, I was pregnant and lumped down after receiving the blow. The deceased stated the accused as to why he was assaulting the woman. The accused then dealt a blow with Juali on the right side thigh of the deceased. Now, the whole allegation is that,
Let us complete it.
my lord,
When my husband,
when my husband interceded on behalf of the deceased, the accused caught hold of his neck. We carried the deceased to Jagannath Prasad Hospital on a cart 3 days after the incident as his condition deteriorated. FIR was also lodged after 3 days. As there was no officer at Jagannath Prasad, I proceeded to Bugda and lodged a written report after got it scribed by one Rao Babu of Jagannath Prasad at Bugda PS. After 15 days of treatment, the doctor at Jagannath Prasad Hospital advised us to take the deceased to Barampur as no further treatment was possible at Jagannath Prasad. We are unable to shift the deceased to Barampur and brought him to the house of the daughter. Daughter name is
House of.
Jagannath, this is Jagannath Prasad. Whatever, take it.
deceased at Jagannath Prasad. 5 days after the deceased died in the house of the daughter. After the FIR as scribed, it was read over by the scribe, after which I put.
Okay. What do you say now?
My lord, the whole allegation is that a blow was given, a single blow was given to the deceased in the thigh, on the thigh. PW 7 is a doctor. Medical report.
The disease is the husband of the informant.
Deceased is the father-in-law.
Father-in-law.
Father-in-law of the informant.
Yes.
PW 7. PW 7.
Who is he?
Medical doctor.
Okay.
Yes, medical officer.
Yes.
I examined Sada Naik, son of Badi Naik of village Patadhar, PS Buguda, and found the following injuries. Right side thigh was swollen and highly tendon.
Sadanik.
Sada Naik.
Yes.
Is a
Right
deceased.
side was swollen, tender. Okay.
Tender.
Right hip joint and Budak was swollen and tender. Fracture of the neck, right side. Neck fracture.
Neck fracture. Fracture of neck of right side femur bone, that is thigh bone. Medical term, that is
Fracture of neck, right side.
of femur bone.
Who is clinically confirmed and also confirmed by X-ray. This is neck bone, neck,
No, thigh bone.
thigh bone.
Yes,
So
ma'am.
that is called as
Neck of right side femur bone.
okay, neck of right side femur
Femur bone.
Femur.
is thigh bone.
Thigh bone.
Okay.
Now, injury 1 and 2 are simple, and injury number 3
This is grievous.
grievous in nature. All above injuries might have been caused by hard and blunt weapon within 2 to 3 days, which is allegedly the Juali, that York.
Yes.
My humble submission is that
And PW3 is also examined.
PW3 is also examined, and it is found that she was not attacked with Juali, she was attacked with fist.
In the belly.
Because in her deposition, she says that she was pregnant and she was hit on the stomach. Therefore, there is no such evidence to corroborate that stand in medical report.
Yes. Okay. Yes.
the body part in which on which the accused attacked is not a vital organ. Since they belong to same family, he must have done with a sheer with a provocation. Since there were quarrel between the family members, with a sudden and grave provocation.
What is your case? You want
I was
you are
26 years.
you are trying to aim at an acquittal or trying to reduce the offense?
To reduce to hurt.
Which offense?
Grievous hurt. 325
You have been convicted.
under 325 and
Mhm.
323.
323. Grievous assault is there. How 323?
My lord.
323. You can't convert it to 323
Because
because of the medical evidence.
mm, because another PW5
Hmm.
he says that he was attacked with a juali,
Hmm.
and in medical report there is evidence that he was also attacked with a blunt object.
Yes.
So therefore 323.
Grievous assault is also there.
323 counts because of PW7.
PW.
PW7.
My lord.
Be happy 325. It should be 307.
My lord, the reasoning of the trial code is that
Hmm.
due to non-availability of medical treatment, due to they were not they did not afford to carry out the medical treatment.
Hmm.
Therefore, the deceased was succumbed to death, not because of the blow.
Yes.
If medical treatment would have been done within time limit, he could have been saved. That's why he was acquitted under 304. Initially, there was 304 also.
Yes. 294, 452, 324, 323, 304.
My lord.
Yes.
He was acquitted and convicted only under 323 and 325.
Yes. You bring it to 323.
My lord, there is if we see the definition
Hmm.
under 325, whoever, except in the case provided for by section 335, voluntarily causes grievous hurt, shall be punished with imprisonment of either description for a term of 7 years. Shall be there.
Yes.
Now on the 322, my lord, voluntarily causing grievous hurt. Now what does he say? Whoever voluntarily causes hurt, if the hurt which he intends to cause or knows himself to be likely to cause is grievous hurt.
Mhm.
Now the part which he attacked, it is not in his knowledge that it will lead to a grievous hurt, because he attacked to the thigh portion of the deceased.
But
And
cause
if-
a grievous hurt.
My lord,
But it
But
cause a
it-
grievous.
grievous assault.
the outcome was
Grievous.
my lord. And if the hurt which he causes is
Can be
grievous hurt,
324, the 324, what's the difference? Sentencing difference, just see. 324 and
324,
324. You can bring it to 320.
which may extend to 3 years. 324.
324. It can be 324.
it was never the intention of the accused to inflict that magnitude of blow. My lord, there is a judgment.
Hmm.
Bombay High Court judgment,
Yes.
paragraph 12, last but four,
Hmm.
last but fourth line.
You read it.
There is an explanation provided to this section, which is to the effect that a person is not said voluntarily to cause grievous
Hmm.
hurt, except
Yes.
when he both causes grievous hurt and intends or knows himself to be likely to cause grievous hurt. But he is said voluntarily to cause grievous hurt if intending or knowing himself to be likely to cause grievous hurt of one kind, he actually causes grievous hurt of another kind. Now, next paragraph, last line, a person is only liable. A person is only liable under section 325 of the IPC if he voluntarily causes grievous hurt.
1 minute.
And-
Though the grievous hurt may be caused in an assault, it doesn't all follows the persons to be assaulted in the guilty offense, the grievous hurt under 325 offense. A person is only liable for 325 code if he voluntarily.
Causes grievous hurt and voluntarily,
What is the grievous hurt?
if he intends to
And
cause grievous
voluntarily
hurt,
causing the hurt, accordingly section 322 of
knew himself to be likely to cause hurt,
knowing himself to be likely to cause such harm.
such hurt. There is one more judgment, my lord.
Hmm. Yes.
Paragraph 21.
Para?
Paragraph 21.
21.
It is a definition part. Now, next paragraph 23.
Yes. Yes.
In the case of Jibawai versus Emperor, it was held by Justice Beeman, that any hurt which endangers human life must also be likely to cause death. And where death is caused as a result of an injury which is not intended to cause death and was not in normal conditions likely to cause death, offense can neither be grievous hurt nor culpable homicide not amounting to murder, and it must be then be a case of simple hurt.
Yes. If the doctor says it is grievous, then
Doctor uses a medical term that it is.
who is
it is-
actually? Doctor is an expert
Yes,
witness.
doctor
He
is
says that it is grievous hurt. How
my-
can the court substitute it saying that no, it's simple?
that medical term to be examined in the light of the text.
And you have used usually that York. This is a dangerous weapon.
It is a blunt weapon.
So you
Blunt object.
can think of converting it to 324.
So then the punishment is 3 years.
3 years.
With fine and with both.
What is the sentence awarded?
2 years.
2 years.
Undergone?
Undergone only 13 days.
Huh?
13 days.
50 days, my lord. 50 days.
50 days.
50 days. Judgment date is
Custody period.
17/7/2000.
Hmm.
High Court re bail move file 2000. High Court re bail 6/9/2000.
Yes. Period undergone?
51 days.
51 days. Is 324. 324.
My lord. Voluntarily causing hurt by dangerous weapon or means. Whoever, except in the case of provided for by section 334, voluntarily causes hurt by means of any instrument for shooting, stabbing, or cutting, or any instrument which used as a weapon of offense is likely to cause death, or by means of fire or any heated substance, or by any means of any poison or any corrosive substance, or by means of any explosive substance, or by means of any substance which it is deleterious to the human body to inhale, to swallow, or to receive into the blood, or by means of any animal shall be punished with imprisonment 3 years or with fine or both.
3 years.
My law.
Exactly, 324 is made up.
My law.
Because it doesn't say grievous hurt or simple.
My law.
If you are using a weapon, dangerous weapon, which may cause death and causing hurt, either simple or grievous, then falls under 320 to 24. Converted to 324.
Yes, ma'am.
And sentence, 2 year sentence was awarded.
2 years.
And reduce the sentence with some fine. 50 days undergone.
Fine will be enhanced.
6 months for it.
We are still 1,000
Total,
fine.
total 52 days
Undergone, na? 52 days. 6 months for it. 6 months sentence. 6 months.
Grateful.
Grateful. Base.
Thanks. 40.
Permitted to appear on behalf of my senior Mr. Chan, Your Lordships. Lordships, the appellant has been convicted under 21B of the NDPS Act, Your Lordships, for a substantial period of 3 years, RI for 3 years, and subsequent fine of 10,000, and in default 6 months, Your Lordships. Your Lordships, there have been 15 witnesses in this matter. 13 witnesses examined, Your Lordships. I'll strictly rely on the part of non-compliance of Section 50 of the NDPS Act, Your Lordships. Lordships, the appellant was found in possession of 5 gram, 200 milligram of the brown sugar, Your Lordships. Your Lordships, the PW8, PW9 being the informant and PW8 being the DS, being the gazetted officer, Your Lordships. Tell Your Lordships, this the option provided, which is the right being provided to the accused under Section 50, Your Lordships. PW9, the informant, being the SI, Your Lordships, has asked the accused whether you want to be searched before a gazetted officer or else.
On to para 12 of the impute judgment.
And
Yes.
The second round of attack has been made on behalf of the defense that the provisions of Section 50, which is mandatory in nature, has not been followed in this case. Accordingly to the defense, the gazetted officer is not competent to ask the accused to exercise his option, which is also shaky in nature, found in the evidence of the prosecution witness, who are police officers, and the accused was not aware of the fact that he had a right to exercise option to be searched in presence of gazetted officer or executive magistrate. In other words, mere asking the accused executive whether he is willing to be searched in presence of a gazetted officer or else an executive magistrate is not sufficient. In support of his submissions, he has relied upon Baldev Singh Vinod versus State. And on the other hand, the learned public prosecutor placed reliance on the case of Kamendra Saw, alias Ramashish Ram. This is at page 25, has canvassed his argument that the provisions of Section 50 is not mandatory. Your Lordship, Section 50 is mandatory as per the Vijay Singh Jadeja, Your Lordships.
No, it's
That matter, admitted, Your Lordships. And Your Lordships has held in Narayan Saw and Anil Saw also, Lordships. recently, and in this case, it is not applicable. The submissions made on behalf of the prosecution has no foundation at all. It has been well settled by the apex court and the high courts that when a personal search is taken, the mandatory provision of section 50 of the act is attracted, and if there is violation, the trial is vitiated. Your lordships, I may take your lordships to the exhibit part, your lordships, where the written option was
What is
provided.
the finding there? What
And
the trial court says
and
ultimately?
The fact of the case on which reliance has been placed by the prosecution is that both the accused persons were coming in a motorcycle, and in this case, it was held that section 50 of the act would not be applicable because a cartoon which they were carrying was found containing ganja. There is some force in the contention made on behalf of the defense that the accused should not be merely asked whether he is willing to be searched in presence of a gazetted officer or else executive magistrate. In this case, PW 1, 8, 9, and 10 have stated that PW 9 asked the accused that he has got a right to be searched in presence of gazetted officer or executive magistrate. No doubt there is evidence that the gazetted officer has also asked something. In my opinion, that would not be a vital point to disbelieve the evidence of prosecution that there was non-compliance of section 50. The asking of the gazetted officer to the accused appears it is for to give the accused sufficient opportunity about his right. Even if the word right is not mentioned there, the question should be put in such a manner that the accused should be made aware of the existence of his right to be searched either in presence of a gazetted officer or a executive magistrate, your lordships. In this connection, they have relied on two cases reported in 2004. Mr. Panda submitted that the independent witnesses have not supported the prosecution version, that the accused was informed of his right, and the written option asked by the inspector and the consent of the accused under Exhibit 3 and the opportunity given by the DSP in writing to get the consent of the accused under Exhibit 6 have been subsequently manufactured, and as those were not produced at the time of the forwarding of the when he was sent to the court, your lordships.
Come to the evidence.
Your lordships. Your lordships, I'll take your lordships to exhibit to
No, evidence first you see.
your lordship PW 8, your lordships. Your lordships, PW 9 being the informant, first he asked whether you want to be searched before a gazetted officer or else an executive magistrate, your lordships. Then he said that, then the accused replied that I want to be searched before an gazetted officer. Then subsequently a requisition was sent to the DSP, your lordships. Then the DSP has arrived. I'll take your lordship to the second option, which we have as to PW 9 is concerned, your lordships. PW 8, your lordships. PW 8 is the DSP, your lordships. The gazetted officer, your lordships. On such and such date, I was DSP City Cuttack. Your lordships, the relevant part is, your lordships. Para 2, your lordships.
Yes.
After my arrival, my identification was disclosed by SI Rautray. I also disclosed my identification before the accused that I am a gazetted officer, and he has got right to opt to be searched either in presence of a gazetted officer or before an executive magistrate. Your lordship has held that whether has observed this, that can the gazetted officer himself ask that if he can be searched before an gazetted officer or executive magistrate. Subsequently, your lordship may see, I also asked him whether he has got any objection to be searched. Is this how a right is being conferred, your lordships? That do you have any objection if I do this?
But he'll read, right? Written it is given.
Your lordship may see the written part also.
Consent is obtained.
Your lordship may see the exhibit
Exhibit
6. Where it
Exhibit
is exhibit 6, your lordships. I have the
3.
exhibit 3 and exhibit 6, your lordships. Exhibit 3, SI Rautray has given in written that whether you want to be searched before a gazetted officer or else executive magistrate, where I opted that I want to be searched before a gazetted officer, your lordships. Both the parts, your lordships may see, it has been written by same SI Rautray. In exhibit 3 also, exhibit 6 also. Exhibit 6, it has been clearly mentioned by many witnesses that gazetted officer has written the same, but But SI Rautre has written it. It has been explained. It has been mentioned in one of the depositions, Your Lordships. I'll go through that. I'll take Your Lordship to that. Now, my specific plea here is, Lordships, the option given under Section 50, which is given in writing, both are in Odia, where rather I have signed it in English. Lordships, I have a specific judgment of this Honorable High Court, where it has been held that if
Why are you jumping so fast? Let us see you have not shown me the exhibit.
sorry, Your Lordship, exhibit
Don't jump, have patience. Come to the exhibit where the written notice was given.
Exhibit 3, Your Lordship.
Where is that? Let's see. Exhibit 3. Exhibit 6. Exhibit 6. That's what I'm searching. Exhibit 4. Exhibit 3. Yes.
ଆପଣଙ୍କ ପାଖରେ
Hmm.
ବ୍ରାଉନ୍ ସୁଗର ଥିବାର ଆମ ପାଖରେ ଖବର ଅଛି। ଏଣୁ ଆମେ ଆପଣଙ୍କର ବ୍ୟକ୍ତିଗତ ତଲାସି ନେବାକୁ ଚାହୁଁଅଛୁ। ଆପଣ ଜଣେ ମାଜିଷ୍ଟ୍ରେଟ କିମ୍ବା ଗେଜେଟେଡ୍ ଅଫିସର ଦ୍ୱାରା କାହା ଉପସ୍ଥିତିରେ
ଉପସ୍ଥିତିରେ ଆପଣଙ୍କର
ଆପଣଙ୍କର
ବ୍ୟକ୍ତିଗତ
ତଲାସି ଦେବାକୁ ଚାହୁଁଛନ୍ତି।
ତଲାସି ଚାହୁଁଛନ୍ତି।
ଲିଖିତ ଆକାରରେ ଜଣାନ୍ତୁ। The same has been written by the same message.
ମୁଁ ତାପରେ ଲେଖାଛି
ମୁଁ ଜଣେ ଗେଜେଟେଡ୍ ଅଫିସର ଉପସ୍ଥିତିରେ ମୋର ତଲାସି ଦେବାକୁ ଚାହେଁ।
ଚାହେଁ। ଠିକ।
ଆଜ୍ଞା। Then subsequently, Your Lordships, Exhibit 6, Your Lordships.
Exhibit 6. Okay.
Your Lordships.
Come to exhibit 6.
ମୁଁ ଜିତେନ୍ଦ୍ର କୁମାର ପାତ୍ର,
ହଁ।
OPS ସିଟି DSP କଟକ। ମୁଁ ଜଣେ ଗେଜେଟେଡ୍ ଅଫିସର। ଆପଣ ନିଜର ବ୍ୟକ୍ତିଗତ ତଲାସି ଦେବା ପାଇଁ ଜଣେ ଗେଜେଟେଡ୍ ଅଫିସରଙ୍କ ଉପସ୍ଥିତିରେ ହେବ ବୋଲି ଦେବ ବୋଲି ନିଜର ଲିଖିତ ମତ ଦେଇଛନ୍ତି। ଏଣୁ ଆପଣଙ୍କର ତଲାସି ମୋର ଉପସ୍ଥିତିରେ ଦେବାକୁ ଚାହୁଁଛନ୍ତି କି? ଯଦି ଚାହାନ୍ତି ତେବେ ଆପଣଙ୍କର ଲିଖିତ ମତ ଦିଅନ୍ତୁ।
Yes.
Then I have
ମୁଁ
accepted.
ଆପଣଙ୍କର ଉପସ୍ଥିତିରେ ମୋର
ବ୍ୟକ୍ତିଗତ ତଲାସି ଦେବାକୁ ଚାହୁଁଛି।
ଦେବାକୁ ଚାହୁଁଛି। ଠିକ।
Your Lordships, I will take you to the depositions, Your Lordships. Lordships may see both the letters where the option was given as well as the right which the accused has opted. Both have been written by the same. The handwriting is same. Subsequently, Your Lordship, it has been written in Odia, where I have signed in English. There is a specific judgment of this Honorable High Court that if the sign is in English, if the sign is written in a way which deems that the accused is educated, then there is a doubt that if it is written in Odia and it is in English, I'll take Your Lordship to you.
If the reverse is there, then you may be correct. It is in English it is written and you sign in Oriya, the reverse is correct. The judgment must be the reverse situation.
I'll take Your Lordships.
Here you are educated, it is written in Oriya, you are signing in English, you are a Oriya guy.
I
That's
am.
enough. That must be reverse one.
Which is my crime.
English is written and vernacular sign. Read it. There the court says, if you have written in English and he signs in vernacular, there must be an endorsement saying that it was read out and he understood it. Therefore, 50 is not compliant.
Your
That's the judge.
Lordships may see this particular.
That must be the anyway. I'm showing it. Sir. Which part?
The citation that I.
2003 24 OCR 781. Right. Para 8, Your Lordships. The signature of the accused finds place at the bottom of the aforesaid document, and that too in English, which indicates that the accused is an educated person.
In the exhibit 6,
Yeah.
whether the second portion is written by the IO or written by the
By-
accused.
Your lordships may peruse, your lordships. Lordship may peruse the
Hmm?
exhibit
There,
6.
it's there with me.
Lordships, I for that. I'll take the lordship.
Same person is written, different person.
Your lordships may see,
Just check it up.
the lordships may see the
We see position. First, let us understand whether it is written by
your lordships, yeah,
the
that part, your
accused
lordship.
or it is written by the inspector himself.
PW 12, your lordships, he has stated in his cross-examination,
And
paragraph 19,
again, you are jumping.
regarding
We are
the
examining PW exhibit 3 and 6.
and
Come to exhibit 3 first. Just see. In the it is written move
ମୁଁ ଜଣେ ଗେଜେଟେଡ୍ ଅଫିସରଙ୍କ ଉପସ୍ଥିତିରେ ମୋର ତଲାସି ଦେବାକୁ ଚାହେଁ।
chahe. This portion is written by the inspector himself.
Because he has signed in English.
Inspector himself, okay? And the signature just see Dilip Kumar Shetty, okay? This signature just see the signature. And come to exhibit 6 now. Exhibit 6 now. Here also the same thing. The inspector himself has written. And Dilip Kumar Shetty here, signature. Okay. Okay, now let us go to the IO.
PW 12, your lordships.
12. What does he say?
PW 12 in his cross-examination, para 19, your lordships.
Para
Paragraph 19.
9.
19.
19.
19, your lordships.
Okay, come to 19.
Lordships, from last one,
Yes.
to fifth.
I have examined Sarath Kumar Behra, son of Gopal Chandra Behra, and he has stated before me that the examiner also evening and time. No, talking about which part?
The lordship, paragraph 19. The lordship
Down
also
to
take
the
the
state
lordship
before
1,
we
2,
get
3,
that,
4. Cross-examination 1, 2, 3, 4, 5, 6.
Read it. Which part?
15th paragraph. I am acquainted with the handwriting and signature of S.I. Rautray.
Which part?
The lordship's cross-examination, paragraph 19.
There are 219. Examination CP is also 19. Anyway,
Cross-examination.
cross 19, yes.
Towards middle.
The written option of exhibit 3 and 6 given to the accused
Ek
are
minute, ek
described by Mr. Rautray
Evidence there here. Written option.
of exhibit 3 and 6
Given
I
to
received this
the
here.
accused have been described by Mr. Rautray.
Mr. Rautray, the informant, your lordships.
Evidence go. Evidence go. And exhibit 3 and 6 also. Exhibit 3, 6 and evidence. Written option of exhibit 3 and 6 given to the accused have been described by Mr. Rautray. I have not seen the contents of the source. That this is an admitted fact now.
Yes.
In the light of this admission, now come to para 8 of the judgment which he is relying upon. Kasina Saw. Come to Kasina Saw, para 8. Do you have the judgment with you? Additional copy?
I have one.
Give it to him.
Yes.
Kasina Saud just speak. Chapat and Pani respond. Take it. In this regard, my attention. Read it. In this regard, my attention was drawn to the notice exhibit 6. Got it?
Yes,
Read it.
Two lines are just not lazy.
Right, Korean language by one Radhu, Assistant Sub Inspector of Excise, whereby the appellant was called upon to give option whether he would be charged before a gazetted officer or a magistrate or by the excise officer himself.
Notice was given by written by one Raju Hoi. ठीक है? Yes, sir.
After the signature of the Sub Inspector of Excise, the Sub Inspector again wrote in his own hand, which is admitted in his deposition before the court below, stating, I do not want to be searched by any other person. You can search me and my house as per law. Again, the aforesaid Oriya version has been translated to English. It is written, on receipt of the notice, the accused Kasinath Sahu willfully agreed to be searched by me in presence of witnesses. Thereafter, the original signature of Kasinath Sahu has been exhibited as Exhibit 6/1. From the tenor
From
of
here,
writing-
here important. From the tenure of the writing,
it appears
it
that the
appears that
entire thing was written by the excise sub-inspector himself. The signature of the accused finds place at the bottom of the aforesaid document, and that too in English, which indicates that the accused is an educated person. This PW4 has explained in his evidence, saying that he had written the contents of Exhibit 6 with the dictation of the accused. He put his signature below the said writing after reading the same. It is worthwhile to mention that Exhibit 6 is a carbon copy of the original document, except the signature of the accused.
the same situation here. Same, next come to 9.
In cross-examination, PW4 has stated that he had not mentioned in Exhibit 6 the fact that the contents of Exhibit 6 were written by him on the request of the accused, and that said Exhibit 6 was not sent to court along with the forwarding report. Non-compliance with the mandatory provisions of the NDPS Act cannot visit the evidence as to such, but certainly it is enough to create cloud of doubt whether at all there was compliance of the mandatory provision or the documents were subsequently manufactured. In order to get an answer, it would be profitable to look at the judgment of the trial court dealing with the aforesaid aspect, as I find the additional session judge proceeded with an impression as if the accused gave it in writing. At page 23 of the judgment, the trial court has observed, in the instant case, PW4, before conducting search, informed the accused that he was entitled to be searched in presence of a gazetted officer or a magistrate, and also obtained from him in writing by the Exhibit 6 that he was also informed, and the accused waived his right to be searched in presence of those authorities and wanted to be searched by him, PW4. This finding is contrary to the evidence on record. There is no writing of the accused in Exhibit 6, barring signature at the bottom of the document, and it is admitted that the entire writing in the said Exhibit 6 was by PW4. That apart, the counsel for the appellant takes me to the charge and draws my attention to the fact that the charge was framed for the offence punishable under Section 21 of the NDPS Act, which provides punishment for contravention in relation to manufactured drugs and preparation.
So the exactly the same situation. Okay? It was written by the PW12 in this case, and in Oriya, and signature was obtained in English from the. This is what is. Yes. How the trial court deals with it? Trial court doesn't deal it with at all. This aspect. Yes.
I have tell your lordships, the Exhibit 3 and Exhibit 6, whether the written option is concerned, that was not forwarded at the time when the accused was forwarded to the court. That was not produced at the time of forwarding, your lordships. That has been highlighted by the trial court judgment itself in para number 12, in page number 13, your lordships. Page number 13 of the judgment, your lordships.
Not paroled.
Admittedly, exhibit 3 and 6 were not produced in the court when the accused was produced. In my opinion, the above omission is not fatal for the prosecution.
Exhibit. Which part you have seen?
Your Lordships, judgment, para number 12, page number 13, Your Lordships.
First, let us see first. I have to underline this part now. 12, 12. Yes. Judgment.
Judgment, Your Lordships, para number 12,
Internal page 13.
internal page 13.
Towards middle, there is some force in the contention of Mr. Ponda. Lots of God.
Yes.
Towards middle, there is some force in the contention of Mr. Ponda. Admittedly, exhibits 3 and 6 were not produced in court when the accused was produced. In my opinion, the above omission is not fatal to the prosecution. The accused in his statement recorded on.
Para, this is which para? So para 12.
Paragraph 12.
Para 12, internal page 30.
Is 13. Yes.
Real part, Your Lordships.
Towards middle, my lord, there is some force in the contention of Mr. Ponda.
When he wrote working house, listen to the east.
75, 70.
There is some force. There is some force.
In the contention of Mr. Ponda, admittedly exhibits 3 and 6 were not produced in court when the accused was produced. In my opinion, the above omission is not fatal to the prosecution. The accused in his statement recorded under section 313 CFPC has never taken the plea that he was unaware of his rights or he was misled by the questions put by PW9 or PW8 and that he has not given writing to any of them. So for this, I am not inclined to accept the submission made on behalf of the defense that there was non-compliance of section 50 of the Act. In other words, the provisions of section 50 of the Act have been complied with in this.
Yes. Yes.
Actually, I'm submitting with Vijay Singh.
Yes.
Vijay Singh.
Hmm.
The section 50 is mandatory, Your Lordships.
That's mandatory.
And I'll tell you, Your Lordships, by reading of the gazetted officer's deposition where he has asked that do you want to be searched before me or any executive magistrate, and subsequently he has asked that do you have any objection if you get searched before me, that does not confer any right, Your Lordships.
Hmm.
That part. And exhibit 3 and 6.
Yes. Section 50 is not complied according to
Yes.
You say section 50 is not complied. That's
Yes.
what is your case. Yes, Mr. Panigre, what do you say?
The requirement of section 50, he has to be informed that he has a right to be served in presence of the gazetted officer or a magistrate.
Hmm.
That option was given to him. He was asked.
You option, you write everything, you have to, notice has to be in due process has to be followed. Therefore, the judgments have said that you have to make him write
Yes.
and then he will sign. Not that you everything you do it and at the end he will sign it. And all are format. And exhibit 3 and exhibit 6, both the exhibits are written by one officer. And it is projected as if the magistrate is written exhibit 6. Just see what is the exhibit 6. See, who has written exhibit 6?
The punishment is stringent, so they have to strictly comply the provisions also. They are always
see.
bypassing that.
See exhibit 6. Mu Jitendra Kumar Patra, OPS.
Yes.
He's the gazetted officer. And
Yes,
who has
sir.
written this? Compare with exhibit 3.
Both are written by that. Is the evidence?
Same है.
there. He has
तो ये
stated
फॉर्मेट
in-
बनेगी लिखी देला आप साइन करोगे पड़ेगा सरला काम.
he has stated
Even
in
the sign
evidence
seems
that
to be that he has written. Dilip Kumar Sethi, Your Lordship, Your Lordship, something.
Sign is also Dilip Kumar Shetty, both the signs are
Same, with
different.
the reference.
I don't know whether he has signed himself.
Admittedly.
There was a see exhibit 3 sign and exhibit 6 sign, just see. Sign is also doubtful. Just see the sign here. Here.
Okay. Here it is in a proportion Y, SETHY, but here it is I. That is the difference.
that itself shows that it is not signed by somebody.
Somebody is the police officer.
They say he has only written, Your Lordships. S.I. Rautre. Yes, sir.
I think these two documents is enough. For executor. Nature of Rautrai, na? Rautrai.
Yes, Your Lordships. S.I. Rautre.
Yes.
Yes.
Forty? 41, देखो, 41. Who is Santosh Kumar Mundo? Not coming.
In 41, already 285 days undergone. Conviction for 1 year.
41 and 60? 63, 65. 63, that's the problem. And keep on life here. 65, huh? Repeating 65. What is the offense? 498 days. Again. Money down. You 65, Mr. Item 65 you assist. It was a 498 day conviction. Only 1 year RI and fine of rupees 1,000. 0.65. Mr. Yeah, point. Get ready.
Yes, ma'am.
Tuesday we'll do it.
Tuesday, yes.
I think. Okay.